Justices of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business to do before this court shall draw near and give their attendance, and it shall be heard.
Thank you. Please be seated. The first case on our calendar for argument is People v. Kellum. It's case number 183. Good morning, Counselor.
Good morning, Your Honors. May it please the court. Krista McDermott on behalf of Lincoln Kellum. Our primary argument is that there's enough information just on the record of the direct appeal for this court to conclude that Mr. Kellum was denied the effective assistance of counsel. But in particular, when it's combined with all of the 440 material, there was at least enough here to warrant a 440 hearing, and it should be sent back for that hearing. This was an extremely close case, even just with the evidence that the jury heard.
Did one of the trials end in a hung jury?
That's correct. The first trial ended in a hung jury. The second jury actually sent a note saying they were also hung.
And they were out for a number of days, right?
Correct.
Like 16 or something. I mean, a very extended period of time. I'm probably wrong about the number.
It wasn't quite that long, but I think it might have been 5 days or something like that. They clearly struggled very greatly with this verdict. They asked for the definition of reasonable doubt to be repeated 3 different times, which I think is a good indication that there was at least one or more jurors in that room who did have doubts here about Mr. Kellum's guilt, and they were struggling with whether they were reasonable. If defense counsel hadn't made so many errors, I think it is very likely that the verdict would have been different. This all really came down to the credibility of one eyewitness, and that's Walisha Hill, who testified at the first trial after she identified Linquan. They said, "Are you sure?" And she said, "No, not really. I don't know." At the second trial, she now claimed to be 100% sure. Defense counsel did not impeach her with her prior testimony, so the jury never learned that at that prior point she had been unsure. The jury did learn that she said in a notarized statement that she was unsure because she was so high the night of the shooting. But what's important is that she denied that that was true. So she said that she only wrote it at Linquan's direction as an attempt to help him. And she and the prosecutor both stressed that she was not under oath when she wrote that statement. But she was under oath in the courtroom when she said she wasn't sure, and the jury just didn't learn about that.
Is there a way to consider it a strategy call to focus on the other statement, the unsworn statement, as well as the love letter testimony that did come out of the second trial?
I don't think it could be considered a strategy because these things all dovetailed together. It just would have made it stronger. The counsel did elicit some of this stuff, as Your Honor points out, but just didn't elicit all of it. And so she was able to explain these things away, and the prosecutor was able to explain them away. And the prosecutor actually falsely told the jury that Walisha had never expressed uncertainty about her identification. The prosecutor said she was always consistent and she was always sure. That was prosecutorial misconduct. We did raise that as a separate point that we're asking the court to review in the interest of justice because it was combined with other instances of prosecutorial misconduct. But it also was ineffective assistance of counsel for not objecting to that prosecutorial misconduct and letting it go by.
Why don't you talk to us about the weight of the evidence?
Yes, this is a case, as I said, that relied solely on this one witness of extremely dubious credibility. I think this is one of those rare cases that this court should substitute its credibility determination for that of the jury. The prosecution at every stage has tried to rely on Mr. Kellum's statements, but those statements don't demonstrate his guilt. They were greatly exaggerated by the prosecution. It really all comes down to Walisha's testimony. This is someone who has expressed multiple times in multiple ways that she wasn't sure if he committed the crime.
Right, I get that. She's the only person who ID'd him. She said at the first trial she wasn't 100% sure. She wrote him letters saying it wasn't him. He wrote him love letters after the murder. But the people seem to rely heavily, as you indicate, on the defendant's statement to the police. In his initial statement, was it not that he was a victim of the robbery himself? He was laying on the ground and he got shot because he had a graze wound on his shoulder. The police and the DA took that to mean that that was physically impossible because there was no bullet hole on the porch floor.
Correct.
So that his story, would you agree, his initial story about how he was shot and robbed defies logic? Now, I know he then evolved, his story evolved and so forth, but that first story that he came out with, I got robbed, I was laying down and I got shot from above. That's contradicted by the physical evidence.
That story, that wasn't on video. We only have the detective saying that happened. And I would just point out the detective actually got wrong what Lin Quan was saying about what we know from the video, what he was saying about how he was shot. And so I think we have to take that statement also with a grain of salt, because the detective insisted that Lin Quan at every stage, even when he changed it to him getting up when he was shot, the detective insisted that he always said the gunman was shooting down at him. If you watch the video, that's not what Lin Quan is saying at all. Lin Quan said that the gunman actually fell after Arthur was shot, the gunman fell to the ground with Arthur. And then Lin Quan was trying to get up. So the gunman was on the ground and Lin Quan was in the process of trying to get up and he shot up at him. Nobody had given Lin Quan any information about where that bullet was found. Certainly nobody had given him any information about the trajectory analysis, but that suggestion that he came up with actually matched the trajectory analysis perfectly. And I think it's really important to point out that Lin Quan told the police clearly he didn't know what position he was in when he was shot. He was trying to help them by trying to figure it out with them and essentially talk it out with them. But he didn't even actually know he had been shot until he got off the porch and he realized he'd been shot.
Right.
So
He was not even considered a suspect at the time he was interviewed.
correct.
He was considered a victim. They were looking for him as a victim. And so the case really does rise or fall on Miss Hill and her credibility. And you raise some significant challenges to that. And we'll take a close look at that issue.
Okay.
Anything further on your other points?
I would just, if the court doesn't reverse on weight of the evidence, I think that the jury note issue would also be a reason for reversal. The court didn't read the entire note and omitted the phrase, "please go slowly." I think that was essentially the crux of the jury's request.
Yeah, we have ORAMA violations, too many to count in this case.
Mhm.
Some are preserved, some are not. But it is kind of surprising in a trial in 2015 when ORAMA was decided, how many decades ago, that court doesn't read these notes into the record, one after another, not a single one.
That's correct. And
But
I would just point out that this was so important for defense counsel to know, because there's no objective definition of what slowly means. That's a subjective thing that defense counsel should have been able to weigh in on. And that just, there's no harmless error test here. It's just, it wasn't read.
the court changed one word on the reasonable doubt charge. The note on reasonable doubt changed the word in there that you say is pretty significant. So we understand your points on those, and as always, we'll take a very close look at them. So thank you.
Okay, thank you.
Morning, Your Honors. Brad Osler for the people. I'll start with the weight and note that I don't see anything from Alicia Hill, who admittedly is the central witness for the people's case, that renders her patently incredible in any way.
Okay, her drug use that night, I mean, there was a lot of drug use to go around in that whole crowd. But she admits that partaking with the other victim.
A small amount, not enough for the victim to sell to her. We'd be speculating, I think, that it affected her ability to perceive.
She has some penal interest problems. She testified she had to get the heck out of there because there was a warrant out for her. And I'm not sure that changed between the first trial and the second trial. She was making deals for her own self. So that actually gives her some credibility knocks right there.
Mhm.
So, her story changed. Okay. So I'm not sure she has anything actually, if credibility has four legs, she's missing three of them.
I would strongly disagree. Her account from the first trial and the second trial, I don't think it varied that significantly. With respect to her I suppose classification that she wasn't 100% sure, or whatever the language was. That's fine. But I don't think it means that the jury was somehow mistaken in crediting her, especially in light of the fact that the defendant was placed on scene by other witnesses. I mean, there's no real question that he was there.
There's no
that he went up to
question he
the
was there.
porch.
Right.
there's really no credible testimony about anybody else being there other than Colbert and Kendricks, the folks who
Well,
were
I
clearly
was
not the
making
assailants.
lists. There were many people that were there,
Well,
and
up on the porch, Your Honor, there's four. There's Hill and Bullock, or five. There's Hill and Bullock, the defendant, and then the two older gentlemen that are standing outside. There's not any credible evidence there's anybody else there. There's no suggestion that anybody else fired a shot or carried a gun to the porch. I'm not sure the jury was left with much other than her seemingly believable account that it was the defendant that
Would you
fired the
agree,
shot.
this case rises or falls on her testimony?
I did in large
There's-
part, yes.
Without her, you can't even get an indictment,
Mhm.
right? Justice Bannister raised some credibility issues with her. As I read her testimony, she acknowledged that she had pending charges for making false reports to the police about another man with a gun. 2 false reports. She was questioned about that and so forth, but it seems that you're taking the position that her testimony is not incredible as a matter of law, right?
I don't think that's debatable, yeah.
Right. Does it necessarily follow that the proof is beyond a reasonable doubt? Like, isn't there a huge gulf between, all right, it's not manifestly untrue. We can't prove 100% it's untrue, but are we then going to conclude that it is true beyond a reasonable doubt enough to lock somebody up for life for murder?
I think with respect to this court's ability to review the jury's determination, it does restrict the court's ability to review that or make that a reversal on that basis. But beyond that, her account is corroborated by a lot of other evidence. And I understand that the defendant takes a lot of issue with the people's emphasis on his story and I think the physical impossibility of that. And, lest we forget, he also provided his clothes to the police, which he said he was wearing at the time, and there's no evidence of blood or a gunshot, which is, just further proof that he was fabricating a story.
Yeah.
I guess for no reason, I'm not really sure. So we look at that, we look at the physical evidence, we look at the lack of other people on scene, it's not debatable that he was the one that went up to the porch at the time of the shooting.
It's not debatable in the second trial. In the first trial, Mr. Kendricks testified that the defendant was a victim and some other man came up and robbed him, but he wasn't. Mr. Kendricks.
Also patently unbelievable. That kind of dovetails into the ineffective assistance claim. I think while I would agree, I suppose, that if you have a trial that ends in a hung jury, to change tactics in a second trial that ultimately results in a conviction might sort of on its face suggest that there was some sort of lapse in judgment. Looking at the witnesses that the defense called in the first trial, 2 of them were really of no moment, and the other 2, I think, lacked, even just on a cold record, any reasonable sign of reliability.
What would be the legitimate strategy, possible strategy for defense counsel not impeaching Miss Hill with her testimony at the first trial that she was not entirely sure that the defendant was the shooter? What strategy could that be? She says at the second trial, I'm 100% sure on her redirect.
Certainly would have been a viable question.
Right. So is there, just trying to come up with any possible rationale here for why on recross examination? So, well, you just said you're 100% sure. In the first trial, direct your attention to this. You said you were not 100% sure. You were not sure at all. So
the cross-examination
what would be the strategy possible there?
This was, I think, laid out in our brief. The strategy that the defense attorney employed in the second trial was, he unquestionably deeply cross-examined Hill at length. I don't remember the exact, amount of pages in the transcript, but it was a lengthy cross-examination to the extent that she was obviously upset on the stand. She at one point seemed to just leave the courthouse and not return after a recess. There is a point in time where you as a trial attorney, you have to balance your actions with the perception that the jury is going to take of what you do. If you are,
that's outside the record. That's but she was outside the courthouse for, we have to look at what's on the transcript.
Well, she failed to show back up, and it's reflect, I mean, the people had to go find her and bring her back.
Right, but if you circle back to the, question about, whether she was sufficiently cross-examined or not on that issue, do you disagree with Justice Lindley's,
What I would say is that the strategy the defense attorney employed in terms of cross-examination, and I mean, if you disagree with me, I'd ask you to look again at the record, but there was a lot of discussion about her jail letters and her shifting stories, and whether she was, felt jilted, I guess, by the defendant and causing her to, try to implicate him more. That was all, very much on display for the jury.
So I guess your argument is that the defendant is not entitled to a perfect representation from an attorney. Yeah, maybe the lawyer should have asked about that. She wasn't sure of the first trial, but in your view is that the cross-examination was pretty thorough.
It unquestionably was.
At some point, good enough is good enough, and you want to try to get a perfect cross-examination, and that's all that the defendant's entitled to is.
I think further cross-examination here, to any measure, to any significant extent, I think it would have been seen as badgering. I'm not sure you would have, that an attorney going even further than what was done here would have felt like he was carrying the jury with them at that point in time. I think that would have been I think it's a viable strategy to employ to at some point say, okay, I've done what I need to do here. The jury can see that she's changed her story, maybe had some motivations to lie. That's the point. That's the point of cross-examination. That was accomplished.
and you believe that the cross-examination was sufficient, that it was on the record basically about her lack of credibility and false reports, and the jury made that determination, and her testimony alone wasn't necessary for the conviction. Is that fair to say? That because of the corroborating evidence that
I mean, certainly I would have to concede that without her, there's no conviction, certainly, but there are things that buttress her testimony, at least a little bit, enough that I think it is reasonable to believe that the jury credited her, that there's a basis that we can perceive as to why that shouldn't be disturbed at this point in time. And it is a lot of the corroborating evidence, even if it's just little bits here and there, but it all kind of adds up. And there's not, I don't think, such a lack of evidence overall that it just goes against the weight of the evidence on appellate review, I think.
Actually, one last question for me at least. You say in the brief that it was 11-1 to convict in the first trial. Counsel takes issue with that. I looked at the jury notice, it's unclear. Was it 11-1 to acquit, or is there inside the record, is there anything that can point us to the answer of which way they were going?
I don't know. I maybe shouldn't suggest that it was necessarily one way. It's the way I read it, but I don't know that
it might not make a difference. If it was 11-1 to acquit, then you might want to follow that strategy again. You might want to change things up. And then the jury was out here for how many, 3 days?
I don't remember, several days. I know it was several.
Yeah.
And obviously they did submit a number of notes. They did hammer on reasonable doubt, had some, I think that we could probably read between the lines a little bit. I'm sure there was some debate between some of the jurors as to, maybe a key piece of evidence, maybe Hill's credibility. I don't know, but the court responded appropriately to all of the notes, read the relevant ones into the record, the ones that were not simply about lunch breaks or pauses in the deliberations. I don't think that
read them, didn't give prior notice on the record. You're supposed to get the note, mark it, read it for the lawyers, ask for input. Here, there was none of that on the record. The judge in some of these just read the note when it was responding to the jury at that minute.
That is certainly that was the procedure. I mean,
it's not correct procedure, right?
Well,
it's just a question of whether it's preserved or not, because you should object if he does read it.
True. I'm not sure if I agree that they rose to an Orama type error, in as much as the notes were provided. There were several of them, not every single one, but a number of them. There were copies handed out to the attorneys in advance of the jury returning to the courtroom. So I think we can see there was a meaningful notice provided, and certainly an opportunity for input. also admittedly, a lot of the notes simply, requesting, can we have reasonable doubt again of charges again? There's not going to be much debate about that, of course, but so I didn't see any error in the handling of the jury notes, but I've covered that in the brief, sir.
Thank you. Counsel.
Thank you.
Case 186 is People versus Antonio Clark, 186. Morning.
Good morning. Good morning, Your Honors. Alexander Prieto on behalf of the defendant and appellant Antonio Clark. In this case, Mr. Clark raised seemingly serious complaints about his appointed counsel, and those complaints were sufficiently specific to warrant a diligent inquiry by the trial court. Mr. Clark described a lack of confidence in his counsel's ability and willingness to represent him effectively if he chose to exercise his right to trial. And he gave concrete reasons for that lack of confidence. His appointed counsel, Mr. Crystal, had pushed him to plead guilty, but at the same time, Mr. Crystal had also indicated to Mr. Clark that he didn't know he hadn't given any thought to how he would defend Mr. Clark if Mr. Clark chose to go to trial. On those facts, Mr. Clark was justified in being concerned about Mr. Crystal's effectiveness because Mr. Crystal couldn't effectively advise him whether to take a plea if he hadn't, at least preliminarily, considered and analyzed possible trial defenses and a trial strategy. So the trial court had a duty to at least to make an inquiry into Mr. Clark's complaints. In considering whether in considering whether the trial court fulfilled that duty, it's important to look at both what Mr. Crystal did and didn't do when he responded to Mr. Clark's allegations in court. First, what he did do, he confirmed that in his assessment, there was a conflict between attorney and client. And what he didn't do, he didn't deny or dispute Mr. Clark's allegation that he had told Mr. Clark he didn't know how he would defend him. He didn't try to explain or justify that statement. He didn't say my words were taken out of context or Mr. Clark misunderstood them. He didn't address it at all. And most importantly, he didn't actually say anywhere that he was able and willing to defend Mr. Clark if Mr. Clark chose to go to trial, as was his right.
Does he have to say that? Does he have to verbalize it as opposed to him saying, like he did here, let's continue with the hearing? And then at the hearing, he's cross-examining witnesses, he's making objections, et cetera. He's participating. Does he have to verbalize, Your Honor, I can meaningfully represent my client?
I wouldn't say he has to specifically verbalize that, but he had to give some indication based on Mr. Clark's allegations. Mr. Clark's allegations put that into question. And the important thing here is that he never responded to that. And then the trial court never specifically dug down and asked about that. All the trial court did was say, well, I'm going to basically assume that these complaints are illegitimate because I previously relieved two other attorneys who were appointed to represent Mr. Clark.
Right. The court, I think you may point this out in your brief, is the court previously made the erroneous statement that you've been given two attorneys prior. This is your third one. The only way you're changing lawyers is if you retain somebody new.
That is what the court told him.
That's what the court told him earlier. And of course, that can't possibly be correct. No matter what the performance of the third lawyer is, you're not stuck with that particular lawyer if that lawyer is not performing up to standards. But the procedural issues, if I could ask you about some of the case law.
Go ahead, please.
We have these cases. I think we're the only department. None of the other departments have cases, but we have case law that says you abandon your request for new counsel if you plead guilty. And again, that rule didn't make any sense to me. And you made a good argument in your brief, very well done, about how that makes no sense. And when I'm Westlaw, I'm like, who could possibly vote for such a rule? And there, my name is on all those cases. So there you have it. But you make a compelling case that cannot be true. That's just not how it should work. We're the only court that has that going back, and the rules changed. Initially, it was if you pled guilty and you affirmatively abandon and say, yeah, I know I made some complaints by my lawyer before, but that's I'm fine now and I want to plead guilty. That's abandonment. Those were our first cases. It's evolved now to you plead guilty, you abandon, which I'm not going to go into the reasons why that makes no sense. You put it in your brief, but we also have a rule, which is unique to the Fourth Department, that says to preserve your contention on substitution of counsel, you have to move to withdraw your plea. We have a couple of cases that say that. Are you challenging that one too? Our case law on that preservation rule?
I would say that in this case, there was no reason to require Mr. Clark to move to withdraw his guilty plea as an issue of preservation. I mean, he covered preservation because he raised the issue, the trial court expressly decided it. So there's no grounds for an additional preservation requirement. In the guilty plea context, the courts require the defendant to move to withdraw the guilty plea. If he's challenging the guilty plea directly, courts require that because it serves the purposes of preservation. It gives the trial court a chance to address the issue in the first instance. Here, the trial court already had that chance to address the issue in the first instance. He raised complaints about counsel and the trial court didn't address them. So to the extent the cases in this department, I don't read them to say that absolutely as a per se rule, if you are challenging a denial of a request to substitute counsel, you have to move to withdraw the guilty plea if you're going to rely on the exception for where the issue implicates the voluntariness of the plea, because it's not serving any other purpose.
To play this out just for a second, he indicates on November 15th of 2021 that he has serious disagreement with the plea, doesn't move to withdraw it. There's 7 weeks before I think the next court appearance, and then we still have another few weeks before sentencing where it seems like there would have been an opportunity to withdraw the plea. If the motion had been made, the people could then step forward and say, well, Your Honor, we believe that he had become satisfied by his attorney. Again, what the Justice Presiding just indicated, I'm fine now, I'm okay now, that's water under the bridge, et cetera. They could have had that issue fleshed out. They didn't because he didn't make the motion. So it seems that the people never had that opportunity to at least make that argument as to how the relationship had changed between the defendant and his attorney, some of which we have support for in the record. Not great. I mean, again, he's answering yes to everything during the plea colloquy, but you understand my point?
I do understand the point. And my response to it is that this is a situation, there was time, yes, but other than the time, there was no practical way for Mr. Clark to make that argument. As far as he knew, Mr. Crystal was his counsel. The court had told him, that's your attorney, I've made up my mind, and you're not getting a new one no matter what. So he could only have moved to withdraw the guilty plea by through Mr. Crystal, with whom the relationship had broken down with at that point.
And if he asked Mr. Crystal, I want you to move to withdraw the plea on my behalf, Mr. Crystal says, no, I'm not going to do that. We've got a 440 issue there, right?
We would.
So either way, it would seem that there's a remedy there for the defendant, but you're saying that practically speaking, we shouldn't put that type of a burden on a defendant because the defendant feels he's stuck because of the comment that Justice Lindley made earlier, where the judge said, hey, this is it, you're on your third attorney and you're done.
But he
Under the
could have said it at
circumstances-
sentencing, though. I mean, the defendant could have said something at the time of sentencing. I know he's standing next to Mr. Crystal, but Judge, I want to withdraw my plea. I don't want to move forward.
Well, I mean, I can't dispute that, theoretically speaking, he was in court, he could have raised his voice and said, I want to withdraw my plea. But the facts was, Mr. Crystal, he had no reason to withdraw his plea because he wasn't confident going to trial with Mr. Crystal.
Right. Your point is that not that it was impossible timing wise to move to withdraw, but there's no reason to do it because he had already been denied new counsel. He already has a lawyer who allegedly said to him, not denied by Mr. Crystal, I have no idea what I'm going to do at trial. If we get there, you should plead. I have not done any planning for trial. So the defendant then pleads like, well, I don't want to go to trial with this guy. And if it's a legitimate complaint about the lawyer and the court did not inquire under sides, it would make no sense for a defendant to bring a motion to withdraw his plea to go to trial with this guy he doesn't feel is competent. So that would be, in your view, an unreasonable rule to make somebody to move to withdraw the plea. That doesn't solve the problem. The problem isn't the plea. The problem is his lawyer.
Exactly. It's unreasonable, I would submit in this case, both to expect Mr. Clark to, at the plea hearing, say, wait, before I enter this plea, I want to re-argue the motion for new counsel that the court has told me it's already decided. That's unreasonable. And it's also unreasonable to expect him to move to withdraw the plea when, as you say, that's what it means. What that means is that he goes to court with an attorney in whom he has indicated he has no confidence.
Could your client bring a 440 now on that issue? My plea is involuntary because the court stuck me with a lawyer I didn't want.
The issue, I'd say, appears on the record. It's not, this is a direct appeal issue. It's not a 440 issue.
Well, what his mindset was, why he pleaded guilty, but in any event, so we understand your point. You got a couple of procedural hurdles based on our prior case law. But we will we'll look at those carefully.
Could I just address very briefly the abandonment point? Because you did raise that line of cases that this court has.
Yeah.
The one thing I would say about that is I don't read those cases. I think the people may, but I don't read them as establishing a per se rule that if you plead guilty with the same attorney after the court's denied a request for new counsel, you per se abandoning it. That wouldn't make sense because abandonment is not a legal issue. It's not forfeiture because of the guilty plea. It's a separate issue. It's a question of intent, and intent always turns on the facts. In this case, the facts don't point to abandonment. So that's all I have, and I'll rest on my briefs. Thank you.
Thank you.
Good morning, Your Honors. Aaron Schwally for the people. Defendant's contention that the court erred in denying his third request for substitution of assigned counsel is foreclosed by the guilty plea, unless the guilty plea implicates the voluntary, or unless the court's alleged error in denying that request implicates the voluntariness of the plea itself. And in support of the argument that does implicate the voluntariness of the plea itself, the defendant relies exclusively on People v. Jones. I would submit that People v. Jones is plainly distinguishable from the instant case. In Jones, very briefly, defendant at the plea colloquy stated that he was only pleading guilty because his attorney was not providing effective assistance of counsel. And in response to that, the court failed to provide defendant any opportunity whatsoever to describe why he felt that his defense counsel was providing ineffective assistance. In fact, defendant tried to give the court a pro se document explaining why he felt his attorney was deficient, and the court refused to receive it or consider it at all. In the instant case, it was not at a plea colloquy, but at the suppression hearing, and the court actually sua sponte brought up through the parties that there was some apparent discord between defendant and defense counsel because defendant had filed some sort of grievance. And at that point, the court essentially gave the floor to defendant to essentially filibuster without interruption from the court to describe why he felt that his defense counsel was not providing ineffective assistance.
Can I stop you right there just for a second?
Sure.
The defendant says that says, I'm not trying to be difficult, but this is my life. This is what he's telling the court about his complaints about his attorney. He said, I tried to bring things up to my attorney, and I asked him specifically, he said, if I do not take a plea, how would you go about this? How would you defend me? And he says, this is the defendant saying about his lawyer, he says, quote, I don't know because I don't even think about it. I didn't even think it would get that far. So the defendant says he's not even planning on defending me. He wants me to just take a plea. He's hyper-focused, exclusively focused on plea. Assuming that to be true, is that a seemingly serious complaint about counsel? That he's forcing me into a plea, trying to get me to plea without contemplating how we would defend us at trial? Does that warrant some inquiry from the court on their sides?
Well, I think what happened at that point is the court turned it over to defense counsel, and defense counsel stated that that's true. He recommended that he take the plea given the sentencing exposure if defendant were convicted after trial and the advantageous nature of the plea, and that he did recommend that he take the plea, but he was more than willing to move forward with the suppression hearing according to his client's wishes.
But he didn't deny that. He said, I have no idea how I'm going to defend you at trial. He didn't dispute that allegation. When I say he, I mean the lawyer.
Sure. But it doesn't foreclose the possibility, if not likelihood, that he would.
Right. Which is why shouldn't the court have inquired, Mr. Crystal, I understand that your advice is that he take a plea given his exposure here. But your client's concerned that if he doesn't want to plea, because he feels he's actually innocent, that he's concerned that you have no plan for him and that you have no strategy, and that you don't think he's worried about what's going to happen when you go to trial. Can you address that? Then he said, well, sure, yeah, I haven't prepared yet, but I will. But none of that inquiry took place, so we never got the opposite side from the lawyer.
I think what the court reasoned was, I think the court probably reasoned that it makes sense that according to the attorney's professional experience that he recommended that he take the plea, but his representation that he's willing and able to move forward with that suppression hearing indicated to the court that he was willing to move forward with the defense strategy as prescribed by or insisted upon by defendant. So I guess, a belt and suspenders approach may have been for the court to say, well, have you thought about a defense strategy? But then I don't think defense counsel would be reasonably expected to say, yeah.
Are you willing to vigorously represent him if he does not take your advice and plea and he goes to trial? How about this rule that we have developed in the Fourth Department and the Fourth Department alone, where we say, if you plead with the same lawyer, you have abandoned your request? That's a little different than the principle you talked about earlier where if it infects the plea, that applies even if you have a different lawyer. We have these cases that say, if you make a complaint, even a valid one, by your lawyer, it's denied, you don't get a new one, then you plead guilty with that same lawyer. Your contention on the substitution issue, no matter how valid, you've abandoned it. That's your understanding of our case law?
Yes, sure.
Does that make any sense to you?
Well, I think there's a little more to it. I think if, as in this case, and probably in those cases, I believe in all of them, or at least in most of them, that at the plea colloquy, the defendant stated that he was satisfied with his attorney's representation. And obviously, conversations off the record can occur between the denial of their request for new counsel and the plea colloquy, wherein the defendant changed his mind and decided that I'm going to take this plea because it makes sense to me. I'm going to take this plea because I trust my attorney. And I think that was probably this court's reasoning for finding that was the request for counsel or new counsel was abandoned. And I think that's what took place here, is that he represented that he was satisfied with counsel.
Right, but as counsel points out, and this makes a legitimate point, is that's a standard question you get asked, the defendant gets asked in every plea colloquy. One of the many questions is, are you satisfied with the representation of your lawyer? If the defendant said no, the court's not going to accept his plea in all likelihood. So the defendant, let's assume this is all true, and I have no idea, of course, what happened between him and his lawyer, whether his lawyer was performed, but let's assume it's true, that you have a valid complaint. If you want to plead guilty, you have to say you're satisfied so that you can plead guilty, because the reason you're pleading guilty is you don't want to go to trial with somebody who you don't have confidence in. And the issue of preservation, he's not challenging his plea per se, he's challenging the court's ruling on his motion with his request for new counsel. So what defense counsel says is that's preserved. He made the request, it was denied, court ruled on it. And therefore it's preserved. I don't know as though any other court besides us requires preservation with a motion to withdraw a plea on that.
Well, the abandonment issue, I would submit, Your Honor, is separate from the preservation issue.
I agree.
The preservation issue, if the court's alleged error in denying the request for new counsel implicates the voluntariness, then the defendant's argument on appeal is essentially that the plea was not voluntary. And if the plea was not voluntary, the defendant must, in order to preserve that claim, move to withdraw the plea or vacate the judgment of conviction, and here neither occurred.
So he would withdraw the plea and he would say, Judge, I know I pled guilty, but my plea wasn't voluntary because the only reason I did is because I'm going to trial with this guy.
Correct, Your Honor. And I would submit that
that would not be granted because the court's already said you're not getting a new lawyer. So why would you bring that motion to withdraw your plea?
Well,
you're pleading guilty because you can't get a new lawyer. So why would you try to undo the plea? Unless you can get a new lawyer, which the court already said you can't get. But I don't know. I'm not sure that our position on that is shared anywhere else in the state, but I will look further. Anything else you want to add to this discussion?
Well, I would just submit that in this particular case, first of all, when defendant the first time requested new counsel, the court stated that I won't provide new counsel, and you have to retain new counsel if you want new counsel. And then he requested it again, despite that warning. And this is a person who's familiar with the justice system. He was a second felony offender. So I don't think this is necessarily a shrinking violent that, somebody that would be afraid to request new counsel over and over and over again and make motions to make sure that he preserved the issue raised on appeal. Essentially, I don't think he would be afraid to raise anything at sentencing if he was not comfortable with with his attorney at that point. So unless your honors have any other questions, I would rest on the papers.
Thank you, Mr. Feller. Case 187, People versus Biles.
Good morning, Your Honors. William Swift for Mr. Biles. This case has to do, I'm sure the court has reviewed the submissions, but this case has to do with a situation where Mr. Biles was placed on interim probation for a period of a year. On the day of his sentencing, the trial court, he was ready to accept the benefit of the plea bargain, the plea agreement. At the day of sentencing, the court was submitted with, the probation department submitted a summary to the court that was vague, the written summary.
And they said that it was vague because they were rushed, I think, for preparing it. They didn't
That's what
think
they,
it. And so they called the probation officer down to court.
that's
right?
correct.
Yep.
They did call the probation officer down to court. With respect to that part of it, the probation officer did come down to court, did not articulate at that point on the record that he indeed made any sort of violation of the interim probation. But one statement in particular that I think was important was he stated, quote, "I don't think he should get a misdemeanor." I think that was reflective simply of his opinion of how the case played out and the benefit of the agreement itself. But the more important point I think here is the 1 year interim probation is what authorizes the probation department to supervise Mr. Biles. Now, admittedly, his plea was on June 28th, 2022. The original sentencing hearing was June 20th, 2023. So that would arguably provide another 8 days of probation supervision at that point. Over my objection, the court adjourned the proceedings to permit the probation department to do whatever they were going to do with respect to this alleged violation. I would submit that they did have the 8 days to do it within their 1 year period of supervision, but they waited until July 13th, 2023, well after that period expired, to file a declaration of delinquency.
What, you've read the Bryan case,
I have.
and how is your case different from Bryan, or is just Bryan wrong?
I'm not suggesting Bryant's wrong. I think the distinguishing fact from my case with Bryant is this. Bryant, they were challenging the court's ability to impose a sentence at all, beyond the 1 year period. That's not my argument. The argument is the delinquency upon which the court was going to deny Mr. Biles the benefit of the plea bargain.
Was there a delinquency or information for violation filed here by the probation department?
There was on July 13th, 2023, which would have been 15 days or so after the 1 year period.
It looks like under the statute that you cite, the probation bar doesn't even have to file any information for delinquency. It's because you're not on probation. It says 6B of the statute that you're relying, and you're relying on 6A, I think. 6B says, in its discretion, the supervising probation officer may utilize the provisions of these various sections, one of which is to file if somebody is not complying with interim probation and information for delinquency. So again, it's not even required, it sounds like, right?
I understand that interpretation, but I think what distinguishes this, Your Honor, has to do with even, I understand the court can rely on summaries and whatnot from the probation department to declare someone in violation of interim probation. In this case, however, there was no formal notice at all, whether it's in the form of a declaration of delinquency or whatnot. There was a vague summary that the court essentially was the one who had opined was hastily provided. And the suggestion in that summary was that he should continue on probation. And I think it bears stating that the alleged violation of the interim probation was not that he didn't comply with the terms, he didn't go where he was supposed to go, he didn't do what he was supposed to do, but that he wasn't fully open and honest. And the question in the court's mind and probation's mind in this case, this was the charges were brought almost a decade after the alleged actions. And this was a rape, an underage victim rape case where my client was
in his 20s, and she was below the age of 16, I believe. So obviously, you know, that was the issue, but it was a 10-year-old case before it was originally brought. Whatever the people's reason for the plea bargain was their reason. I think what they put on the record was that they wanted to spare the victim, and that's laudable. But I think this is a case clearly of buyer's remorse. They didn't like what had happened. They didn't like what he was getting. But at the end of the day, what I wanted to point out was the alleged violation was that he didn't admit to having sex with the victim as many times as probation believed he had it. And the record of the hearing, I cross-examined both the probation officer and the treatment provider, and neither one could tell me what the actual number was.
But you're not challenging that on appeal. I don't read your brief as challenging the court's finding that there was a violation of intern probation, because I agree, it's a seemingly plausible contention. It wasn't, he showed up for every meeting. He didn't commit any new crimes. He actually went to sex offender treatment, did everything. There was many conditions, right? The only one he arguably violated was one that he had to cooperate at treatment and admit all his wrongdoing. And that was what the hearing was about. But your brief doesn't challenge the court's finding that he actually violated it. Probation.
Conceitedly, that's not in the brief, Judge, but I think it bears noting, and I think it flows to the totality of the circumstances here. And I think really the big question is, for going forward with defendants and accepting plea agreements, I think it's very important that if probation is going to allege that somebody violated their terms in this 1-year condition, that some sort of notice be provided to the defendant within that 1 year. Now, again, I stated earlier that the original sentencing provided for another 8 days of the violation. The fact that they chose essentially another 3 weeks to file this declaration and this formal notice, I think is problematic.
Yeah, I guess the problem that I have is the law doesn't require 393, doesn't require any notice of violation, information for delinquency or anything else. Doesn't really require it. And your point in point one is the court's resentencing based on an alleged violation was improper. Assuming we were to agree, well, your client has to be sentenced, right?
Correct.
So, and his intern probation is not a sentence, right? He wasn't.
That's correct as well.
You can't continue that forever. We know that. So what should happen if we agree with you? We would vacate the sentence that was imposed, which was probation. He got shock probation, but he's already done the 6 months. And send him back for resentencing and he gets probation again?
My proposal is that he gets the benefit of the plea bargain. He vacates the sentencing. He's allowed to plead to the misdemeanor and gets what he bargained for. And I think that's the issue here. He relied on that. He did what he was supposed to do. You know, that was our position.
But there was a hearing saying he did not comply, and you haven't challenged that. But I understand your point would be, well, you need to have that determination made within a year, or the allegation made within a year. But so you want the misdemeanor in 6 months for 6 years probation. That's what you want.
Yeah,
That's the remedy, is what you
original,
want.
correct. That's what we'd be asking for. And I think just procedurally speaking, that, you know, the argument is such that they had time to do this. They came into court. There was not a notice on the day of this original sentencing, just a vague statement about, you know, we don't think he's progressed as far as we think he should in treatment, essentially. I did object to adjourning the sentencing, so.
I was gonna say, you went into court thinking your client's gonna get the misdemeanor and everything's fine, and lo and behold, you were surprised.
That's correct, Your Honor. And I did object on the record to an adjournment for the purposes, and the court in that situation blatantly said, I'm going to adjourn this to allow the department to essentially investigate and figure out what their position was going to be. I mean, that's not verbatim, obviously, but I just think he didn't get the benefit of what he should have. And
It did seem like he got the deal of the century that you negotiated for him. Deal of the century.
I agreed, Your Honor, and I
he
think
he was allegedly raped a 14-year-old many times. Gave her Oreo cookies in response to the allegations. He pled to it. And you negotiated, if you just comply with probation for a year, you're going to get a misdemeanor in probation.
why the people made that offer, Judge, I have no idea.
And I think what it looks like what might have happened is one of the victims showed up at, I think maybe there's some second thoughts there.
Well, Your Honor, and I think that's bared out by a statement that one of the prosecutor made on the original day of sentencing, where she stated in sum and substance, I'm not happy at all with the way this case was pled. it was on the day of sentencing that she made that statement. So I suggest that this is a case of buyer's remorse. I do believe he got an unbelievable plea deal considering the circumstances, but I think he was entitled to rely upon the benefit of that bargain.
But if the case is returned as a misdemeanor, wouldn't you just say he served the 6 months and that's the sentence, there's no probation? Is the argument you're gonna make when you go there? Yeah.
If he's got 6 years in. Yeah.
6 months in.
He does have 6 months in, Judge. That is true. I think that's a potential argument he could potentially have. I did not consider that's what the argument we were going to make. I do believe it. He could still get a split sentence.
He would get probation for 6 years. He's got probation for 10, he would get probation for 6, but the big win for him is that the felony drops down to a misdemeanor.
That's exactly right, Judge. That's the motivation here, is not the sentencing portion. It's the fact that he's tagged with a couple of felonies now at this point.
So he's just out of luck on the 6 months he already served.
The way this played out, I think that seems to be the case, Judge.
Thank you, Counsel.
Thank you.
Your Honor, Caitlin Porter on behalf of the people. Just to address quickly, the discussion on whether or not this would ever return as a misdemeanor for resentencing would only be if this court were to find that the lower court abused its discretion in finding that there was a violation on interim probation. That contention is not raised on appeal. The only contention that's before this court substantively on the IP claim is that it was a jurisdictional issue, that the court lacked jurisdiction to sentence the defendant when it was outside of the 1 year period of interim probation. It was only outside by a matter of weeks. But regardless, this exact issue, virtually identical facts, an identical claim, this court addressing People v. Bryant.
Well, Mr. Swift he argues it's distinguishable in that in Bryant, the issue was, can you sentence somebody after the year? Does the court lose jurisdiction to sentence somebody? And if the court does, then the conviction is vacated, the plea is gone. That seemed to be the issue in Bryant. He's saying what he's arguing, I don't know if what he's saying today is 100% consistent with his brief, but what he's saying today is that his argument is not that the court can't sentence after a year, but that there has to be a notice of violation within a year from the probation department for somebody who's on interim probation. That seems to be his argument. Because there was no notice, he should have been given the benefit of his bargain. Do you see any requirement in the law for a declaration of delinquency or a notice of violation or anything from the probation department if there's a violation?
None whatsoever, not on an interim probation term. Interim probation is not a sentence. It's a pre-sentence condition. It's well established that that follows the procedures identified in Article 400, not Article 410, which is what is cited in defendant's brief, is all of if a defendant received a sentence of probation. This is not a sentence at all until the point that they return to sentencing. It's all happens before the final imposition of sentence. And as for what's articulated here at oral argument versus what was raised in defendant's brief, the defense counsel has said here that they're not making a jurisdictional challenge. I read the entirety of that point in their brief as a jurisdictional issue, that that line in subsection 6 of 39030 is deprives the court of jurisdiction to sentence after 1 year. Just
to be clear, if a defendant is placed on interim probation and the probation department doesn't file any notice of violation, can the court just review the pre-sentence investigation or based on what the prosecutor says and say, we don't believe he's compliant with interim probation, absent any notice from the probation department? And then the sentence promise is revoked. Is that permissible under the law?
It essentially follows the outline of cases, and that the court just has to assure itself that a sentence is reliable and accurate. The information it's relying on is reliable and accurate. There is no requirement for a formal DOD, a formal violation, but we do in this case, though, have the interim probation summary, which is not included on the record on appeal, but it was referenced, it was quoted extensively when the parties did return for sentencing. So the court did have the IP summary that was written by the probation officer. And to Justice Kane's point earlier on why it might have been a little bit confusing was because after articulating the violations, it was done in haste. The sentencing proceeding was a week earlier than it was originally planned on being. And after articulating the violations, the probation officer did indicate that they would be willing to continue working with the defendant on probation. And I think that's where the confusion was, because the question was whether that was misdemeanor probation, whether he's been successful, or felony probation, which would have been one of the permissible sentencing options if he was deemed unsuccessful, which was what he effectively got in this case. So that was really the confusion. That's why they brought the probation officer in to appear in person in court to clearly tell the court, I think he's been unsuccessful, should not get to the benefit of withdrawing his plea. And that's the point where the court set it for a hearing. So it's really just whether the court could assure itself that the information it was relying upon was reliable, accurate. We have an extensive hearing, a full evidentiary hearing where one was not even required. The court could have conducted a summary hearing. It's all within the court's discretion. The court certainly had enough information before to conclude that he was unsuccessful on interim probation, and there's no jurisdictional bar to the time that the court sentenced the defendant. Aside from that, just very briefly on the sentencing point, I would certainly agree with Justice Lindley that this was the deal of the century. The defendant got a probation sentence. It seemed to surprise all of the parties that were there. Even the court itself said that it needed some additional time to think about it, but did end up giving the defendant probation to really give him.
Even after the violation.
Even after the violation. And it said that this was very unusual given the allegations, but I think part of it had to do with the probation department's willingness to continue working with the defendant, even despite his obstructionist behavior and not willing to admit any of the allegations during sex offender treatment. The court was willing, or the probation department was willing to continue working with him. So I think that's why they ended up giving him the sentence that he did, but it was extraordinarily lenient, particularly in the nature of the allegations. The victim's statement was incredibly compelling.
I think the court even mentioned that it was the worst that they had seen in 30 years, correct?
Correct. And the court did grapple with it and needed an additional adjournment for sentencing. Said
it was your office that offered the misdemeanor.
It was a different prosecutor that came in later for the ultimate sentencing and that conducted the hearing. I don't think it's
not relevant to the
right.
appeal here. So, all right. Thank you very much.
Thanks, Joe.
188 is People versus Fox. Mr. Keem is remote. Your opponent has submitted. Mr. Keem, good morning. You may commence your argument, please.
Good morning. May it please the court, Brad Keem for Heather Fox. We argue that the verdict should be set aside, or a CPL 33030 hearing should be ordered. Juror 10 made sworn claims that she felt like a fish out of water, that juror number 1, the daughter of a court officer, provided some legal definitions, and that most concerningly, juror number 11, a loss prevention associate, vouched for Yager, who was also a loss prevention associate, assumed that Heather was a criminal because there are signs you pick up on if that's your job. Now, I understand that the court, it summarily dismissed Heather, or juror number 10's statements, really because it focused on juror 10's statement in her affidavit that no one asked her if that was her verdict. But there's several explanations for that. She could have misunderstood what the court was saying, or more relevant, and I think likely, was that she felt intimidated by jurors number 1 and number 11.
Counsel, if we could go back for a second, I'm not quite sure if intimidation by a fellow juror might be enough, but certainly the one juror acting as an expert, vouching, like you said, as to the loss prevention, claimed that she had her own experience in loss prevention that apparently wasn't disclosed during the voir dire process. But my question to you on that, is it material? Because it seems to me this whole issue as to what the juror was commenting on, the juror that claimed to have this expertise in loss prevention, why was the security officer, whoever it was, I forget the title, following her? Why was he watching her, following her the day that this happened, the day that she filled her cart with the items in the Walmart? So what? Who cares? Why does that issue matter?
Well, I think it speaks to intent. Intent for her, how she was shopping and what she was doing. You know, her defense is really that this was a mistake. She went through the cash register line, went to the service desk, and basically forgot to pay for her stuff. So if you have a loss prevention officer that says, no, this person was following her because he saw something different about her that would
He
demonstrate.
saw that wasn't the expertise, so to speak, that people who bring their own bags into a grocery store are suspected of possibly they're going to steal. Which makes no, I mean,
Yeah, in
makes
today's
no sense in this day and age. Maybe like before they made you pay for bags, but I'm not sure that qualifies. If she's an expert, I'm not sure I'd call her as a witness in any of my trials.
Well, Your Honor, I think that it's important that these kind of questions that we're all having should have been sussed out at some kind of hearing, as opposed to just summarily denied because there was some kind of misunderstanding in her sworn claims about what jurors 1 and 11 had said to her. And then I would ask the court then to order that hearing. And unless there are questions on our speedy trial issue or any of the others raised, then I'll rely on my brief.
Thank you, Mr. King. Case 189, People versus Anton Kelly. Duffy, good morning to you.
Good morning. May it please the court. I'm Casey Duffy on behalf of Mr. Anton Kelly. Focusing on point 1 of my brief, Mr. Kelly's conviction must be reversed because the trial court twice erred in denying multiple requests for substituted counsel. First by Mr. Kelly more than a year before trial, and second by defense counsel himself about a week before trial. Mr. Kelly first requested a new attorney in December 2020, following a 6-month failure by defense counsel to schedule a legal visit to discuss his case. During his next appearance in March 2021, before Mr. Kelly was even present in the courtroom, defense counsel complained about the number of letters and questions that he was getting peppered with from his client. The court, in response, simply took counsel at his word as an officer of the court that he would remain in communication with his client going forward. Then, once Mr. Kelly was present in the courtroom remotely, the court failed to pose to Mr. Kelly even a single question about the substance of the underlying dispute with counsel and the background of what his frustrations were. Then, the week before trial in February 2022, it was defense counsel who requested appointment of a new attorney. He informed the court that he was, quote, pissed off that Mr. Kelly had filed a grievance against him regarding counsel's continued failure to show Mr. Kelly the complete unedited version of his interrogation video taken at Syracuse CID. Defense counsel expressly told the court that he was not sure.
Wasn't that in Irondequoit? He was interviewed by the police in Rochester?
That's correct. I apologize.
Okay.
Yes, it was in Rochester.
Right, so his complaint was, my lawyer, I was interviewed for a long time in Rochester, 3 years after the murder in Syracuse, the homicide. And his complaint at that point was, my lawyer didn't show me the entirety of my interrogation, right?
That's correct.
The court does inquire on that, if I'm not mistaken, and the lawyer says, I did. And he sent the letter to the court, I showed it to him many times, the entirety. But let's assume he didn't. Wouldn't your client have to show some relevancy? Like, he was there, right? Wouldn't he have to show some relevancy? Why do I need to see the entire interrogation?
Because the missing portions of the video that he had seen, the prosecution had prepared sort of a highlights version that did not include statements that Mr. Kelly contended were exculpatory. Detective Marola, when he testified before the grand jury, said that there were portions of the interview where Mr. Kelly said that, he was on his phone, he was in the car, he wasn't even aware of what was happening outside the car at the time Mr. Abraham was shot. So that is the underlying nature of the
Right,
dispute.
but the lawyer said I showed it to him in its entirety multiple times. So the court asked, so what then? The court, your client's entitled to a new trial because he says, I didn't see the whole video. The lawyer says you did. The court's supposed to side with the defendant on that?
I think the fact that Mr. Sullivan said in open court that he was not going to represent Mr. Kelly as vigorously as he would had this grievance been filed sort of nullifies whatever the substance of the underlying.
Okay, that's a fair point.
But then a plea took place.
But then a plea did take place.
And we've sort of talked about some of those issues related to a plea with, your current lawyer that you're allegedly unhappy with.
Right.
So.
And I know there was some discussion of whether or not that constitutes abandonment of the claim. But just to rehash that in this case specifically, I think it clearly does not constitute abandonment. This is exactly the kind of situation where Mr. Kelly's request for new counsel was denied and he faced the impossible decision. Do I plead guilty and mitigate the harm of going forward with an attorney who had just said in court that he was not going to represent me as vigorously as he would otherwise, or continue to trial and sort of roll the dice and see what happens?
And unlike in the prior case we had this morning, Clark, your client was not asked during the plea colloquy, are you satisfied with representation of your lawyers? That question was never asked.
I believe that's correct.
So it's a little stronger abandonment claim in the first case than in this one.
That is correct.
Your client, he moved to withdraw his plea too here, right?
Almost immediately.
So we have no preservation problem as we do in the other one. And so really, in your view, it comes down to the merits. Did he make a seemingly serious complaint? If so, did the court inquire as required by People versus Sides? And then did the court properly deny the request for new counsel based on what the lawyer's response was? Yours is merit based, you would say.
And I think there's, the further indication, which is almost dicta in the trial court level, where before Mr. Kelly was sentenced, the trial court told him that he believed that there was no merit to his complaint, because even if it's true that those exculpatory statements had been edited from the video, they would not be admissible because they were not statements against his own penal interest, which I think is demonstrably incorrect, and that he would have been entitled to have the entire video with its full context played in court. And again, I think this is all after the fact, the court trying to explain to Mr. Kelly why, he thought that this was a meritless complaint. But, ultimately, the way the process shook out just demonstrates how unfair that was.
So you agree, though, just filing a complaint against your attorney doesn't get you a new attorney per se. What you have here is the complaint for the grievance against a lawyer, and then the lawyer saying, I'm angry at him and I can't represent him as vigorously as I would because he just filed a complaint with me with the grievance committee. That's the extra what we have here in your view, right?
Well, I think there's two. There's the conflict of interest that Mr. Sullivan describes that's created by the grievance. And then there's also sort of an irretrievable breakdown of communication between an attorney and his client. So regardless of the substance of the dispute, I think Mr. Kelly was entitled to appointment of a new attorney. And I would just emphasize that this is not a case where he went through a succession of attorneys just because that's personality conflicts came up. This was the first attorney that he was appointed.
There was a Court of Appeals case this morning, People versus Fredericks. I don't know. You were probably preparing for this argument. Didn't see it.
I did not see that.
Okay. All right. I won't ask you about it then.
You don't want to spoil it for me?
Well, it's not good for your side. I'll just say that.
That is bad. And if I may make one additional point, is that respondents' argument that the sides issue is somehow moot due to the fact that Mr. Kelly was represented at times by a second chair attorney is basically a red herring. The record shows that attorney had little participation in Mr. Kelly's case. And in any event, this court shouldn't affirm on this basis under People versus Concepcion because the attorney's continued representation was never a stated basis for the trial court's denial of new counsel.
Thank you so much.
Morning, Your Honors. David Bassett for People. This is a case where timing is critical. When did the defendant move to withdraw when did he plead guilty? He pleaded guilty midway through trial, not right after his request for new counsel was denied, not right before trial, midway through trial, when the evidence was coming in against him, when an incriminating video had been shown depicting him with the victim of the homicide right before the homicide. Therefore, our position is that this was an abandoned claim for a new attorney. He pled guilty later on.
But not long after the defendant claims that the attorney came in and said, gee, I didn't work on your case last night because I was too busy working on the grievance. Right?
Excuse me?
Not long after the defendant claims that his attorney told him that he didn't work on his case the night before, mid-trial, because he was too busy responding to the grievance. Isn't that testimony? Or
I believe there's something that the defendant's mother said to that effect.
Okay.
But if you want to look at the merits.
But if that's true, because we don't have a hearing here, right? Is it, I mean, if that's true, not a good look to say.
Not a good look.
I know your trial's important to you, but my grievance, I gotta get some work done on that tonight. I mean, you can see where a guy might want to plead as soon as he hears that.
Well, I think it's important to back up and look at the representation during the trial. There's no alleged deficiency whatsoever that counsel fell short in any way. The record shows that he, thoroughly cross-examined witnesses. He was prepared for this case, and that his representation was reasonable under the circumstances at trial. And then, as I said, the defendant decides to plead guilty because of the timing of this case. He sees that the evidence is coming in against him, video evidence highly incriminating him. He knows he's facing 40-year sentence, talks to his mother, who says, this doesn't look good. Maybe you should take a plea. He ends up getting 14 years, which counsel secured for him. Under the circumstances, that was a fair deal, and it reflected a knowing and intelligent and voluntary choice to plead guilty.
Wasn't his motion to withdraw the plea based on coercion from his own mother? Is that what
That's part of it. And, that's not a cognizable claim to withdraw his plea here, that his mother, made an emotional appeal to him to take the deal because she was worried about him going to jail for a long term. And that motion to withdraw was properly denied based on the colloquy, which shows the defendant's plea was knowing, intelligent, and voluntary. The court says it was made with quite a bit of intelligence after consulting with your attorney, your mother, thinking about how the evidence is playing at trial, makes the decision to plead. Court says, I have to note that this is happening right after these videos were played, which were critical to the people's case. So it's our position that motion to withdraw was properly denied.
It's not like he pled to the charge. He got a reduction and he got 14 years. Could have had 25 to life, right?
Correct. I believe it's 25 plus a weapons charge, potentially 40 years. So under the circumstances, this was a reasonable decision, a strategic and calculated decision, weighing the pros and cons of proceeding with trial versus taking the sure thing, the plea for the less time.
And the attorney, as upset as he may have been about the grievance, still sort of seized an opportunity when that juror issue came up, and we were going to have to question all of the jurors with respect to what he said. And that was when the plea came through.
That's my reading of it, Your Honors. There's a point where one of the jurors comes forward with this vague claim about what another juror said. And the court says, oh, well, I'm going to have to bring in everybody to talk about this. At that point, it appears that defense counsel sees the opportunity to hash out this deal. And they come back, they go through the colloquy. Defendant is asked, do you want to go this route? Is this the deal you want to work out? He says, yes. The judge asks him, are you agreeing that you, committed this crime? He says, yes. Are you doing so knowing, intelligently, and voluntarily? Yes. He's not asked specifically if he's satisfied with his attorney, but he's asked if he has any questions for the court or his attorney, and he says no. Therefore, under the circumstances and looking at his age, 30 years old at the time, experience with the criminal justice system, the timing of this plea, the colloquy, all those circumstances add up to a knowing, intelligent, voluntary plea and a waiver after that, which, forecloses additional claims.
Thank you.
Thank you.
Next case for argument is 191 matter of will of Rodriguez.
May it please the court, David Sealing on behalf of the appellants. The supervising attorney of the execution ceremony called this not the worst deathbed signing he'd ever seen. In this case, on this appeal, raises the obvious question, how bad does it have to be? As stated in our brief, there were several undisputed facts which called for greater scrutiny and at the very least denial of summary judgment. The court below is faced with conflicting facts, and the role of the surrogate was to determine the existence of those conflicts in the evidence, not resolve them, not make determinations of credibility. There was conflicting evidence on every issue below. Evidence which was received by the court. And I think this case kind of tests the limits of the presumptions afforded to an attorney's supervised and drafted will. The undisputed facts.
On a motion for summary judgment, the court's not supposed to make credibility determinations, even if they are present for testimony or present for the argument. In this case, it was before a referee.
Understood, yes. And it's a difficult position because ultimately the determination to admit a will to probate rests on the surrogate on several of the issues. The surrogate's satisfaction is the standard under SCPA 1408. So ultimately, in duly granting a motion for summary judgment and approving a will for probate, there are some credibility determinations which are necessary, but no, in this case, where there is conflict in the evidence.
Well, on summary judgment, your point is credibility the evidence should be viewed in the most favorable light to the non-moving party, and no credibility determination should be made on papers, but this case is a little unusual. I haven't seen this one before.
It's rare to have the day and hour so well documented.
Well, what I was looking at, I hadn't seen, we get the appeals from 22 surrogates, been here 15 years. I have not seen a case where a beneficiary under a will agrees with the objection to the will with respect to capacity. The Margarita, I believe, was one of the three. There were 10 kids. 3 are gonna get his estate. One of the 3 puts in an affidavit and says she herself has concerns. He was confused, he didn't know what he's doing, but Mr. Valentino makes some legitimate points in his brief that affidavit contradicted some testimony. And we have this principle that you can't raise an issue of fact, a feigned issue of fact, just put in an affidavit if it contradicts testimony. Because that is an important statement she makes. My own father, who's giving me all this money, he was confused. He didn't know. But what about this conflict issue with her testimony?
Your Honor, these depositions were also conducted through a translator. I think a full view of the record, and as stated in our brief, will show that the questions asked, well, can you remember? The questions asked, I don't think demonstrate a conflict, but even assuming there was a conflict, the sole case cited in support of this proposition and the full holding of that case is a self-serving affidavit, which is in conflict with the testimony, is going to be ignored. This is the opposite of self-serving.
Isn't every affidavit almost by party self-serving or what? But in any event, so you don't think there's any conflict with the affidavit in her testimony?
Her testimony, when read in full, she gives several instances. The proposition that she could never recall a time when he was confused is not borne out by the full transcript. That's our position. And we do not perceive a conflict in her testimony, which, coming from the proponent and the drafting attorneys who had several affidavits in this matter, after the fact, supplementing 1404 testimony. That side, the court received those affidavits, weighed them, considered them, and determined that they were credible and gave effect even to the affidavits offered in reply.
We had this issue about the name of one of the daughters being changed from the notes of the attorney, and then by the time the will got drafted, it was Madeline was substitute or vice versa. There were 2 similar names, one from one mother, one from another. you want to be heard on that? And what are you suggesting there, that his notes say one daughter and then the will that gets drafted a couple of days later has another daughter with a similar first name but different? What are you suggesting there, that Myra, the other daughter, corrected him and gave him the name of her sister?
We're suggesting that there's evidence to that, and that evidence could not be resolved on summary judgment. There's testimony that the drafting attorney did not know the other names of the other children. There's testimony that he did not speak with the deceased between the initial Zoom call meeting for which the translator was never provided. The only thing in that meeting which would not have required translation were the names.
So Madeline was Myra's sister with Margarita. The notes had Maribel. The lawyer's notes had Maribel, and then the will comes back with Madeline.
Yeah, and the explanation offered, again, in reply, is that at some point I must have learned and there must have been a typo, but the only person.
Myra says she never talked to the lawyer.
I'm sorry, Your Honor.
Myra, is my understanding, her testimony, she didn't talk to the lawyer between that initial meeting, that virtual meeting, and when he showed up with the will. But I think the lawyer says that he did.
That would be yet another conflict in the evidence. Because he testified to that more than once, if memory serves. I'm happy to point to the record in a further submission if that's necessary. However, again, the object of responding to a motion for summary judgment is to raise facts, show potential issues, and that goes to both undue influence as well as due execution. When you have a circumstance where this man couldn't read the will, this man could not read or speak English. He was giving one-word answers in a 10-minute ceremony when only moments before medical professionals had done assessments.
I was gonna say, weren't there hospice doctors who said that he was only oriented as to person, but not time or place, like,
One said place,
right?
one said only person. And that was why it was important to have some sort of testimony below from a qualified person to say, what does that mean? How many things can you be alert and oriented to? You'll see in the decision and even on the respondent's brief. Oh, well, he knew who he was. Well, that's not the standard, and that's not what the nurse's notes indicate as interpreted by someone competent to read them. We think that.
Well, you had Mr. Zia spoke Spanish. He was there. And he said, fine to me.
And also,
he doesn't have any horse in that race, right?
I'm so sorry. Could you repeat the last part?
Mr. Zia, he doesn't stand to benefit one way or another, but I guess your point is like, let him testify at trial, and maybe you win, maybe you lose at trial. You just don't want to lose on papers.
And there was yet another conflict. In the original 1404 testimony, he similarly had notes from his execution ceremony, which were in conflict with later affidavits saying, no, all the questions required by, 4 years later, all the questions that were required by EPTL 3-2.1, I did ask those, notwithstanding their absence from the memorandum. And he testified that he had almost no experience with estate law or estate planning at the time of the execution. I don't know if he has since. Just briefly, with respect to capacity, another element of Dr. Rich's affirmation, which was overlooked by the court, is a real description of the condition from which Alejandro Rodriguez suffered. This is not a progressive brain disease. You'll see in the decision, you'll see in the respondent's brief, well, there's no record he had Alzheimer's. He didn't have Alzheimer's. He didn't have dementia. He had hepatic encephalopathy. This is more akin to intoxication. This is a blood poisoning, which is objectively measurable. And in review of the hospital records, during the time when the initial meeting would have been taking place, and as a result of his discharge to hospice, when all treatment would cease, it's very clear if he was drunk, we wouldn't be asking ourselves, well, did he have 5 minutes of undrunkenness? This is intoxication. His brain was not sick. His brain was poisoned by his blood.
He knew all the names of his 10 kids, right?
He did have 10 kids.
But he knew the names.
There's no indication that he did.
Did he know his property, all these had rental property?
There's testimony that he did know his property.
It's not.
There's testimony to that effect.
Yeah.
And there's testimony to the fact never asked the names. Assuming, which I won't do. I'll leave it there. It was not asked about the names whatsoever.
All right, but your main point is that there's at least an issue of fact here that should be warranting a trial on that.
On several segments, and there's decisional law which doesn't fit into what's the standard of proof. I think I said heightened standard in my brief when probably the better term would be stricter scrutiny. Because we have things where we say, hey, if you're related to the lawyer, then that needs an explanation. That doesn't fit into our normal question, but we're already here on summary judgment, which is any question of fact. And there are conflicting facts in the record here that warranted a trial.
Thank you.
Thank you.
Mr. Valentino, welcome.
Good morning, Your Honor. May it please the court and opposing counsel, my name is Christian Valentino. I'm an attorney with the Law Office of Plano and Farrow, and I represent Myra Rodriguez, who is the then appointed, or excuse me, nominated executor of the estate in Alejandro Rodriguez's will. Now she is the appointed executor. It's Myra's position that the circuit court actually correctly determined in this case, based on this record, that summary judgment was warranted. I'm not going to get into all the facts because I know that Your Honors have read the facts, and they were detailed because there were so many people that were involved in this, that there was 9 depositions of all of the children, except for one who's been missing. But I'd just like to highlight a few things and comment as well on some of the arguments that opposing counsel made. Let me start with fraud and undue influence. All of the cases that come out of this court regarding undue influence and fraud require certain elements, and they're just not here. The record does not demonstrate a question of fact on any issues of fraud or undue influence. With respect to fraud, for example, I asked every single of the children, are you aware of any lies or misrepresentations told by any of the 3 named in the will, or anybody else for that matter, to the dad before he died that caused him to change or make a will? Answer, no.
Right, but there's not the question asked, did you make any misrepresentation to the attorney?
I did not ask that. They wouldn't have known whether or not.
Well, right, but your client essentially is perhaps being accused of telling the attorney at some point, oh, when he said Maribel, he didn't really say Maribel, he said Madeline.
Yeah, my client was deposed for quite a length of time, and that was not any of the testimony, nor was it asked.
That was not asked. But that's what's essentially being represented, because in order to affirm here, what we have to assume happened is that they had a meeting over, I don't know, it looks like a couple of phones, 2 phones, one with an interpreter, one with the nurses. This is the original meeting that we had. And at that meeting, that the decedent said the word Madeline, and the attorney wrote down the word Maribel without knowing that he had another child named Maribel. That's what we have to believe necessarily occurred. Right?
Respectfully, Judge, I disagree with that because.
Okay, so he said something, he said a name, he wrote down a name, right? If he said Maribel and the attorney wrote down Madeline, we have an issue of fact and we need to have it here, right? That's easy.
Actually, I disagree, Your Honor, and here's why.
Okay.
So the February 19th, 2021 meeting is what you're referencing, which had to be done via video conference because of COVID. Attorney Proco was very clear in his testimony, unequivocally, when he was asked Mr. Rodriguez what he wanted to do. After he established he had 10 children, approximately 30 grandchildren, they joked around about that. He asked him about his assets. He said, I have property in Rochester, New York City, and Florida. And then he asked him about the consequences of signing the will. And the testimony was that he said they get my money when they die. What do you want to do when you die? And he's unequivocally, the attorney Proco testified that it was Myra, Margarita, and Madeline.
Right.
Then the testimony is when it came up of this issue that there were notes in the file that were produced during discovery. So Attorney Proco did everything correct. It was the memo was in his file. It was produced. It was Maribel. When he was asked to explain that through the affidavit, he testified that days later, not that day, he was dictating the memo. Likely it was on February 23rd, the day that the will was signed, and he mistakenly dictated Maribel.
Right, so
So-
at some point he learned the name Maribel.
Correct.
Even though the decedent said Madeline 4 days earlier on the 19th, I think it was, not the 21st.
Correct.
4 days later, he said the name Madeline. At some point, he must have learned the name Maribel, but he claimed that he never found out the names of the other children. And Myra, your client, claims she never told him the names of the other siblings.
Right.
So that doesn't work. It doesn't make sense. Why don't we at least have an issue of fact?
Well, two reasons, Your Honor. First and foremost, the law is clear that it's what happens on the day that the will was executed is all that matters in terms of whether the testator was able to identify the natural objects of his or her bounty, in this case, his bounty, general understanding of the assets, and the consequences of signing a will. Unequivocally, just like Attorney Proco testified about the February 19th meeting, the February 23rd meeting was the exact same thing, that he identified he had 10 children, approximately 30 grandchildren. He even asked him questions about what happened. Do you remember having a conversation with me 4 days ago? He indicated that he did, demonstrated that he did, and that was testified to by both Attorney Proco and Attorney Zaya. And then, so to answer your question, what happened on the 23rd is relevant here in terms of, did he have capacity that day?
Sure, and it would be a little bit easier if the will, as typewritten, it came to the house. The will that accompanied the attorney to the house was typewritten with the word Maribel, and then they crossed it out and they initialed, no, I meant Madeline. Everything would be easier if that's what happened, but that's not what happened. The will said Madeline, it didn't say Maribel.
Right.
And when they got to the house, interestingly, Myra was there and Margarita was there because they had lived there. Madeline didn't live there, but Madeline was there, wasn't she?
Right, because she was helping taking care of her dad, unlike the others.
Okay.
So-
And she was in the room momentarily before they had the private meeting.
No, Your Honor, the testimony
Attorney
is,
Zaya doesn't say that she was in the room? I realize that
No, I
Attorney Proco may not, but Attorney Zaya doesn't say that all three of the daughters were in the room prior?
no, that they greeted the attorneys at the, when they got there, and then Myra brought him, the attorneys to Alejandro, who was in his room and in his bed.
So you don't think the record suggests anywhere that the daughters were in the room with Alejandro before the attorneys got there?
Correct. None of the daughters were in the February 19th meeting, and none of the attorneys, or sorry, none of the daughters were in the room with Alejandro where he signed the will.
I know, I appreciate at the time of the signing of the will. I'm saying before that.
My recollection of the record, Your Honor, and if you found something different, I'll apologize. That's not my intent to mislead the court.
Okay.
My recollection of the record is that they were identified as the attorneys, and in fact, Margarita testified, I knew there were attorneys here. And I knew they were going to go talk to my dad about the will. She never referenced at that point in time, why are they here? Or I object and he's confused, you know? So to go back to Your Honor's question, though, it doesn't create a question of fact, because the unequivocal testimony is that Alejandro said on the 19th, Myra, Madeline, and Margarita. And then 4 days later, same thing, unequivocally testified that the words out of the testator's mouth were Myra, Madeline, and Margarita. So from our perspective, this admitted attorney error, dictation error, typo, however you want to describe it, is a red herring, because it doesn't have any bearing on what was actually said by the decedent on the day that he signed the will, which
Right,
took the
so
law.
let's say that there was a mistake.
By the attorney?
No, by Alexandro. He mistakenly said Maribel instead of Madeline. He said, let's just assume that on the 19th, he just made a mistake. He intended to leave it to the three, to Myra, Madeline, and Margarita, but he just mistakenly said Maribel instead. Your point is that it doesn't matter, because on the 23rd, if he's competent, he read it and he went through and he saw the name Madeline. He didn't see Maribel. And it's like, yeah, this is what I want. And he signs it. So regardless of whether the lawyer made a mistake in dictate and taking it down, or Alexandro made a mistake in misnaming who he wanted, Madeline was in the will on the 23rd. If he's competent, we have to presume, presumption of regularity, everything, that's what he wanted, I guess is your point, that he wanted Madeline. And there's some reasons, I guess 5 were from the first mother, 6 were from the second, well, from the wife.
Yeah.
allegations. The first 5 really didn't spend a lot of time with him, didn't take care of him, so forth. So there's, I guess your point is that it's consistent with, it's not irrational that he would want to favor those who have spent more time with him.
Right. I would say, Your Honor, exactly. It's not irrational, but why he decided to do what he did, what Margarita thinks should have been done,
Right.
frankly, even though she's getting money and she's siding with the objectants, why she thinks it's unfair has real no relevance here.
Right.
But to Your Honor's point, it is rational that he decided to select his 3 daughters. He had provided for the 2 sons from the second marriage, and he bought that New York City property with the second wife and built it up with the second wife and maintained it with the second wife. So it's logical what he did, but I understand that today we're here on whether or not this is summary judgment warranted, and it is. And raising the issue of the attorney admitted error where he just said the wrong word, and to go to Your Honor's point, there's testimony by Attorney Proco that at some point in time, he learned the name Maribel as some of the other children. And a bunch start with M, and when he noticed the dictation error, when he reviewed the memo, he fixed it right away. And that's an error of the attorney that doesn't necessarily impose a question of fact on the validity of the will, because there's no dispute that the testimony that came out of the testator's mouth, both on the 19th and the 21st, no dispute at all, or no evidence to demonstrate that it's wrong, is that he identified the 3 daughters that he wanted, and that was consistent on the 19th, and most importantly, what he said on the 21st.
Should we be concerned at all with the fact that the attorney, at the time that he's representing that the witness had capacity, that the attorney is also representing one of the beneficiaries? Should we be concerned that that's a conflict, or no?
That he's representing the daughter who is named as the nominated executor of the will?
No, they represent the daughter who's the beneficiary of the will, not the executor, but the beneficiary of the will. And of course, if the will goes through, she stands to earn a lot more.
Are you saying?
So then the question as to whether or not the decedent had capacity at the time he executed the will, critical question. If he says yes, that benefits his client. If he says no, it hurts his client.
Yeah, I guess I'm confused. Who are you saying that Attorney Proco was representing other than the estate, and Myra Rodriguez as the executor of the estate?
I think he's representing Myra Rodriguez as beneficiary.
No, he's not. No, he's not. No, and in circuits court all the time, this happens all the time. The attorney who's representing the executor of the estate is representing the estate through the nominated executor. He was not and is never, he doesn't represent Madeline, although Madeline is on the side of Myra, so to speak, has never represented Myra as a beneficiary of the estate. Attorney Proco only represents the estate through the appointed executor through the process of getting the will admitted to probate.
So he's getting paid the same regardless if it's Maribel or if it's Madeline.
Oh, yeah.
It doesn't matter to him. He has no reason to lie here, I guess. But I guess your opponent would say those are credibility issues that you can't resolve on summary judgment. So we understand there's some disputes there.
But it's a credibility issue on why he made a mistake in a memo. It has not a credibility issue as to what was told to him, because it was clearly identified the reason. And it's even if, I mean, you would have to assume, and there's no evidence in the record that he was representing Myra. Myra had very little to do other than introducing them, and that's all in the record. It wasn't an attorney that she's used before. None of those elements that are typically in an undue influence or fraud case are there. There was no isolation, no lies or misrepresentations. None of this came out in the record that there was anything like that. So to me, coming in here today, I thought the biggest issue is the testamentary capacity issue, which, as your honors pointed out by questioning Mr. Sealing, Margarita's testimony in her deposition was very conclusory. I kept asking a number of different questions regarding, well, do you have any examples? No. He was confused. Give me one example. Couldn't do it, right? Then she tries to submit an affidavit that creates it. But even if you actually look at that affidavit, it is largely conclusory, other than stating, well, he used to mix up some of the names some of the times, like we've all been doing, right? But the testimony on the second affidavit is also, he looked confused. He was confused on the day and the time that he signed the will. Doesn't say what about it. Doesn't say that he couldn't identify the natural objects of his bounty. didn't state that he didn't know whether he had property, didn't state that he didn't know the consequences of signing a will. And that same problem for the objectants is in the affidavit submitted by Dr. Rich. Number one, he doesn't even identify the difference between contractual capacity and testamentary capacity. He doesn't even state that he wouldn't know the natural objects of his bounty. He doesn't state that he wouldn't know his property. He doesn't state that he wouldn't even know the consequences of signing of the will. He says he wouldn't have been able to participate in estate planning. Again, that's a conclusory statement. And not even identifying the threshold that is necessary, the very low threshold necessary in New York State to sign a will. I know why it's not in there, because he couldn't say it because it was directly contradictory to the facts of the fact witnesses who are actually there.
So the capacity to sign a will is less than a contract, right?
Absolutely.
And there's a lot of deathbed. I mean, that's when people want to probably sign a will. The fact that this was toward the end isn't necessarily unusual.
Absolutely. And there are cases that were cited by Judge Chacho at the surrogate court level, and they're in my brief. I think it's Burroughs and Amato. There was pro-offered medical testimony through an affidavit, and summary judgment was still warranted. And it's for the same reasons here. Conclusory, doesn't identify a threshold, or is most of the time contradictory to the facts that were testified and irrefutable. Nobody else was there on the 19th. Nobody else was there on the 23rd. And on the 23rd, the two attorneys, one who has extensive knowledge and experience in this area, and they both identified, he identified the things he needed to identify, and there's no question of fact on it.
One last question for me is, we see in some of these cases from surrogate court, somebody who is facing death or is older, we have some videotape interview at the time that the will is being executed, asking questions so that we can see, right? And that's very helpful for us to see what this guy sound like, what did he look like? We don't have that from either the meeting on the 19th, the virtual meeting, or on the 23rd.
Correct.
Okay.
Yeah.
Doesn't mean that it's required.
Yeah, it's not required, Your Honor. And frankly, you ask most experienced estate attorneys, why don't you do that? And they said it's not necessary. All I have to do is provide the testimony of what I saw that day and what I heard that day. And that's all that's required. Video is not required. And as long as you can meet that low threshold, and he did on the 19th and he did on the 23rd, yes, the attorney messed up by dictating the wrong word. But even the question of fact of how that occurred, Your Honor, does not create a question of fact to invalidate the will.
Anything further?
I don't believe so. Let me just double check one. No, we hit it all, I believe, Judge. Thank you so much. I appreciate your time. Thank you.
Thank you. Case number 192 is William Mattar PC versus Bridget Riley. Mr. Sullivan is remote and counsel for a respondent. I'll go with that. Okay.
Fine, Your Honor.
How do you say your last name?
Sahas Rodriguez.
Okay.
Peter works fine.
Peter. Okay. Thank you. Mr. Sullivan, good morning.
Good morning. May it please the court. This is a basic breach of contract action. Indeed, in Ms. Riley's counterclaim, she alleged that she entered into a binding enforceable contract with my client. And indeed, during in his opinion, Judge Wojtasek said that the parties are in agreement as to the essential terms of this bonus plan. And the terms of the bonus plan were really clear and unequivocal, that there would be a bonus paid for cases that had cleared revenue, meaning the settlement was complete, the fee was deposited in the firm's account, and at the time of that cleared revenue, the employee, in this case, Ms. Riley, had to be employed by the firm. Now, one thing we have to keep in mind was she was paid her salary all throughout this period of time. There was never any withholding of salary. And in fact, as a result of discovery, there is no dispute that each of the cases for which she was claiming an entitled bonus, the cleared revenue came in after she left the firm, which, if it is a clear and unequivocal contract means that she is not entitled to the bonus. Now, what Judge Wojtasek did was cobble together different concepts from different cases to arrive at a result I think he wanted to arrive at for whatever reason. But
Counsel, shouldn't we be focused on the issue as to whether or not the agreement violated public policy? It really isn't that the whole thing? Because the agreement says what it says, but the problem with it is that the attorney could only do so much, get the releases done, settle the case, et cetera. And then, in terms of, the payment of the amount, getting into the correct bank account, and then waiting the 10 days, that's really not on the attorney. So to add that limitation, to add that factor, which of course has a lot of practical consequences if you do that.
Sure.
Wasn't that what both the Court of Appeals found in the Colkins case, if I'm pronouncing that correctly, and also what Judge Wojtasek found violated public policy, that the delay violates public policy?
Well, I don't think Judge Wojtasek found that, with all due respect, Your Honor. What he found was that she had earned the bonus, that it was earned income. Now, the distinction with the Colchins case was there were two different plans, first of all. And the Colchins case was a case which involved whether or not there was an agreement in the first place. And the Colchins case also acknowledged that the parties are free to set the terms of their own employment agreement. It's very specific, right in that case.
Wait a minute. I've got to stop you there because I saw that in your reply brief, and your point is that the terms of the case rises or falls on the terms and conditions of the bonus agreement.
Correct.
And what Colkin said is, as a general matter, employees' entitlement to a bonus is governed by the terms of the employee bonus plan.
Correct.
However, so it's not general matter means in most cases, but not all. Then it goes on to say, however, Article 6 of the labor law, so forth and so on, and the Court of Appeals makes it clear that the entitlement is, if you have in a contract or a bonus plan, some provision that a bonus earned is not received if somebody doesn't work there anymore, that's unenforceable against public policy. That's what I took out of Colkins, is that it's not strictly the terms and conditions of the bonus agreement. Is there some conditions that are void? One being, if it's earned, you can't fire somebody and not pay them. You read it differently?
No, I don't, but the Colchins agreement was different in terms of the circumstances under which and the period under which the bonus was indeed earned. It was an entirely different concept that they were denying payment under. All the Colchins case agreement that was found by the court found that if these things happen within this period of time, the bonus is indeed earned. That's not.
Is that a matter of content, or is that really more of a matter of semantics? Because you could say, well, we'll say it's earned, but then forfeited. And then Colkin says, no, you can't do that. Can't forfeit it once it's earned. How about this? How about we just say it was never earned to begin with? Because it's not earned for, I don't know, a period of time. And then we can always fire the person in the meantime.
Well, no, that's
not what we have here.
No, respectfully, Judge, no, because Colkin said that the computation, the alleged agreement in Colkins was the computation was based upon receipts that were received while you were working there. Okay? While you were working there during quarterly events. These receipts were received in a certain quarter, and your bonus is based upon those receipts. We're not going to deny you the bonus because you left after the period of time, the quarter in which they were earned. This is an entirely different contract for a lot of reasons.
Right, and I get that, and you make that point in your brief. Do you agree that as a general rule, True Love is talking about, and Colkins also talks about discretionary bonuses and non-discretionary. You concede here that this was a non-discretionary bonus if earned. If earned, it's non-discretionary, right? Would you agree?
That's correct.
Okay.
I agree with that.
All right. So Your point then is under the employee bonus eligibility plan for 2019. It says to receive these bonuses, says shall, which is not discretionary. Said in order to be considered revenue, fees must be deposited into the firm's operating account and have cleared the account for 10 business days. This is called cleared revenue.
Right.
Your point in this brief and on this appeal is that it was not cleared revenue yet because it hadn't cleared. And therefore she's not entitled to that because it hadn't cleared. Is that right?
Yes, and it came in after she left. I mean, in the settlement of contingent fee cases, you settled the case, and oftentimes the payment is not for several months after the
No,
settlement.
I get it. So, but her point is that the work that she did is complete at that point. Now, I know you say that's not enough to get the bonus, but what if we had these facts? Under the same agreement, she settles the case. Ms. Riley settles the case for $3 million. And so there's $1 million fee to the firm that's bonus worthy, right? Because it's over the $550,000.
Oh, yes, yes.
So she settles the case, gets a stipulation settlement. The insurance carrier sends a check in. The check comes to William Attar's firm. And William Attar will take it even further. He deposits it into the bank, and it's there for 9 days. They fire her on the 9th day. And would you say she doesn't earn the bonus on that because it hadn't cleared for 10 days?
Under the terms of the agreement, yes.
Okay.
But you also have additional arguments in that case as to good faith, those kinds of things, as the reason, because of the size of the fee, the reason that she might have been terminated. There's a lot
How about good faith with respect to the timing of the deposits, not the size of the deposits? Could William Attar, check comes in and they just hold it and they don't deposit it? They could control when it clears, and they can then control whether she's entitled to a bonus for work she's already completed. Right?
There's no evidence of that here, Judge. In fact,
I know, but
all of the dates of deposits were agreed upon, and all of the dates of when the money cleared were agreed upon.
Counselor, could this clause be void against public policy? I mean, where's the 10 days come from? And in this day and age, things electronically clear, and it could be a few days. Why do they need 10 days to hold the money?
Well, I don't know the answer to that, Judge, because that's what they decided to do. I assume in a personal injury firm, that's standard practice to make sure the money is actually cleared and in the bank. That's not unusual to me at all. I mean, it's what the agreement calls for. And see, one of the issues here is, I think a key issue, is that Judge Wojtasek actually wound up rewriting this agreement to reach the result that he wanted to reach. And by that, I mean, he determined that she earned the fees under the terms of the agreement, when in fact, in the strictest sense, that's not the case.
because they hadn't cleared for 10 days. How about this last?
And she wasn't employed.
Right. Well, no, okay. Now that's where we get, let's say that a check clears, but she's fired, so she's not employed anymore. Then we got Calkins. Calkins, my understanding is, as Justice Noack indicated, public policy says you can't fire somebody so as to deprive them of a bonus that's been earned, wages that have been earned.
There's no question about that, and there's no indication that that was the case in this situation.
Well, she was fired without any notice on November 20th.
But there's no indication that she was fired to avoid paying her a bonus.
Right. So they would have to get a trial to get to intent on that?
Well, I mean, Judge Wojtasek granted summary judgment, and in fact, going back to Calkins, I believe that the court there, or at least in Truelove, said that whether or not wages are earned is a question of fact. And Judge Wojtasek decided, and it's a quote, as a matter of law, he is awarding her these fees under this agreement, when in fact, that violates the terms of the agreement.
Well, so you're suggesting maybe it should go to trial, but in the way it was set up for Judge Wojtasek was you and opposing counsel agreed, here's our papers, here's the other papers, you make a call, somebody's got to win summary judgment. Under the way you guys set it up, nobody's going to trial. This is up or down legal issue, right?
I think that that is absolutely correct. And also, if I may add one other point here, the issue of attorney's fees under the labor law, he dismissed the labor law claim. And it's my understanding that there is no labor law claim if you got a breach of contract claim. That's been pretty clear over the years. And this was sued as a breach of contract claim, and he granted summary judgment on the contract claim. So I don't know how you can mix and match the different the statute into that particular decision, as he did, parse out the labor law and say these are wages under the labor law, when in fact he already decided that they are earned bonus fees under the terms of this contract. They're just completely inconsistent to me. And again, it's a contract action. You may not like the terms of this contract. You may not like what happened in these circumstances, but that's the agreement that was entered into. She had received bonuses in the past. There's no indication that she was fired to avoid paying her a $21,000 bonus. And we think Judge Wojtasek just got it wrong and wanted a particular result and tried to cobble together something that's inconsistent with the terms of the agreement and the decisions in Calkins and Truelove. Thank you.
Thank you, Mr. So.
Thank you. May it please the court. Peter Sosrabude from Hodge and Russ on behalf of Bridget Riley. I want to start, Your Honors, with what has never been disputed in this case. It's never once been disputed by the Matar firm that Ms. Riley's bonus compensation was non-discretionary.
He conceded it this morning
He
again.
conceded it this morning. It's a non-discretionary bonus. It's also never been conceded by the Matar firm that her bonus this year would have constituted over 40% of her expected income. That's an essential component of her compensation package. So what do you have when you have a non-discretionary bonus that is an absolutely essential component of a compensation package, one that all of Matar's attorneys expect and work there because they have the ability to obtain a bonus? What you have is earned wages.
Well, he says it's not earned because the money hadn't come in on some of these by the time she left, and it hadn't cleared for 10 business days.
Well, and I think you hit on this earlier, Justice Lindley. It absolutely is earned because under the law, she did the work and labor required to be entitled to that bonus. And what's happened here is that they've drafted their contract in a way that allows them to strategically part ways with an employee at a time that they can say, oh, well, we don't consider it earned at that time, so we're not going to give it to you, even though you've done all the work, you've obtained the settlements. All that's left is for the check to clear the account.
The most important part is the money. So let's say that Ms. Riley settles a case and gets a jury verdict or a settlement for however much, 500,000, we'll say, and she leaves right after that. We don't know if there's going to be if the award could be collectible, right? You got to have insurance coverage. We don't know. There could be liens. Lord, no. I mean, so would you agree if she leaves before the money comes in, how is she entitled, how does she earn it under this agreement here?
Well, what's undisputed and what Matar admitted in their discovery responses is that they did get payment for all of these settlements.
Later, after she left.
Sure, but within months. Sometimes it was actually the payment was in and it just hadn't cleared 10 days, right? And so if you adopt the position that they're asking you to adopt, you are, this has implications beyond this case. It has implications beyond the legal industry and the legal field, right? What you are allowing employers to do is to say, okay, an employee has a bonus coming in. We know that based on our contract, but let's part ways at a strategic time so that we can reap the benefits of their labor and not have to compensate them what we agreed to.
So counsel, I guess defendant did everything she needed to do to earn the money in your estimation. She got the releases signed and basically we're just waiting for the money to come in.
Yes, Judge.
Okay, and they said that she wasn't fired to avoid paying her. And is there something that we don't know about why they parted ways in between the time that she settled the case and was expecting, this money to come in and it coming ready to be paid?
We don't know. Matar's never given an explanation. My client has asked. It's never been given to them. It's never been given in the proceedings below. They've had ample opportunity to give an explanation. No explanation's been given. But even if an explanation were given, right, it could be a ruse. It could, you could give any explanation you want.
We might infer from the timing.
Absolutely. And I would say, given the timing of her termination and given the timing that some of these checks came in, that's a fair inference.
And in light of no other explanation in the record.
Absolutely. An explanation that has never been given, not when she was terminated, not when we briefed the issue before Judge Watazik, not when we briefed the issue before this court. It's never been given.
So whether she earned it turns on the intent of the employer of why they fired her?
No, it hinges on what she did to earn the bonus as an employee of the firm, her labor, her time, her effort. That's what it hinges on.
Regardless of when the money comes in, as long as it eventually comes in.
Yeah, if it comes in, what you did here within months, right? Within months, I think that
we're going to ignore in this agreement, we're going to strike out this employer is no longer employed by the firm under Calkins. That's not enforceable in your view, right?
It's void as against
Right.
public policy.
But then
Yes.
we're also going to cross out, we're going to do a lot of crossing out here. We're going to cross out this sentence that says, in order to be considered revenue for the bonus, fees must be deposited in the firm's operating account and have cleared for 10 successive business days. We'll cross that out too, right?
Well, yes, Your Honor, because what that does, it deprives her of money that she was promised and that she put in the work to get.
What else are we going to start crossing out here?
Those are the only, in my estimation, those are the only two.
Okay.
And that's a fair, enforceable, legal contract when you cross out those two provisions. And that contract with those the two provisions crossed out, promote the public policy of this state that exists for good reason, that you can't withhold money that has been earned by an employee. You can't withhold earned wages and you can't draft a contract to do it.
Because your position would be that if the money was not collected, that would be their argument that they couldn't pay her.
100%, Your Honor. But that's not and in fact, they've admitted they got the money.
And sometimes you see these things with real estate brokers and they make lists of when they leave, but they're still entitled to it for years later sometime if they worked on the deal. And here, for some reason, the law, is this a common, are you familiar with this clause? It seems unusual to me that you would have this clause saying that it has to be in collectible funds for 10 days, otherwise.
I'm not judging and
standard law firm clause and
I'm not sure, Judge, but what I am sure of is that Colchins is pretty clear that if you're trying to enforce that kind of provision in the way that the Matar firm tries to enforce it here, it's void against public policy.
Calkins didn't have the 10 days clear type language. It had can't fire somebody to avoid it once it's earned, but.
The specifics of Colchins, though, aren't really what's relevant. It's more the general premise that it states pretty clearly that the Court of Appeals says pretty emphatically in that case.
Opposing counsel indicated that, we don't have allegations that there was something underhanded here. And in looking at the counterclaims, I don't see a counterclaim for wrongful termination. I don't see a counterclaim for fraud. I don't see a counterclaims for the type of thing that, oh, you fired me in order to deprive me of this. Do we need that? And if not, why? Why don't
you don't, Judge? You don't, because the reason for the termination, although I agree with Justice Bannister that there's an inference there, there's certainly an inference. It doesn't matter. Whatever the reason of termination, when she's earned the wages, she's entitled to them. That's the law. So even if there was good cause, which we don't know because it's not in the record and no explanation's ever been given. The reason for you don't need to find that there was bad faith for Ms. Riley to prevail on her counterclaims in this case. I want to briefly touch on the labor law point. So labor law claim was separate and apart for our claim for breach of contract. And it didn't just ask for liquidated damages, right? It asked for reasonable attorney's fees. And the labor law here is pretty clear. It's unequivocal. If the court finds that earned wages have been withheld by an employer, then the employee is statutorily entitled to reasonable attorney's fees. So the court, I disagree with Mr. Sullivan that the court dismissed the labor law claim. The labor law claim is not dismissed. There's a portion of the claim that he said is dismissed and that Ms. Riley can't recover on, and that's the request for liquidated damages. But the claim itself survived, and he actually awarded relief on the claim, which is the claim for reasonable attorney's fees, which, because the undisputed evidence here is she did the work to earn her wages and the wages were withheld, she's statutorily entitled to her reasonable attorney's fees under the labor law. So we ask that that portion of the decision be affirmed as well.
Thank you very much.
Thank you.
Case number 193 and 194 is Ramsey versus Stevens. Good afternoon.
Kevin Haverfield for the appellant. May it please the court. The trials that we're here about today were fundamentally unfair. And the record's replete with instances where the improper jury charges were given, evidence was excluded that would prevent a jury from coming up with a fair verdict. I'm not going to get into all the parts of the brief, but there are a few points I do want to start with right out of the gate. And I'm going to start with the end, and I'm going to start with the loss of chance instruction. Contrary to Fourth Department precedent, I provided to the trial court Justice Curran's white paper where he details step by step how you do this.
We are very familiar with that.
Oh, I'll bet. And the court decided they wanted to forge their own path. They didn't want to follow the Fourth Department's precedent, and they wanted to charge substantial probability instead of substantial possibility.
So that one word difference, probability for possibility, is wrong. And is that enough in and of itself to get your new trial? And that, I know you got a lot of issues here, but that alone is enough on loss of chance?
Absolutely. And most of these charges that have been raised in the appeal by themselves, just that individual charge is enough to get you a new trial. But this one in particular, and certainly all of them as a whole, certainly warrant it. And
You were the trial attorney.
yeah, the possibility versus probability distinction is important because possibility is there's a chance something occurred. Probability is the quantification or the numerical value, the likelihood.
More than likely.
That it occurred, right? And that's exactly what all the cases in this department say the plaintiff does not have to prove. You do not have to prove the quantification of the loss because it's impossible. The fact that someone wasn't treated, you don't know what would have happened had they been adequately treated. And it's the difference between it's possible I could win the lottery versus I have a 1 in a million chance of winning the lottery. It's also important because it burdens the jury with coming up with this numerical value, with figuring out what is that likelihood, percentage, statistic, whatever it may be. And it's also terminology that was never expressed to the jury through the entirety of the trial. So we get to the jury charge, and for the first time ever, they've heard possibility of loss of chance. Now they're hearing probability of loss of chance, and it's a jury charge from the court.
And that was discussed and argued before the court gave that charge, that the use of those words in particular.
At length, yes.
Okay, and there was an explanation by the court for that choice?
There was, if I recall correctly, it was something along the lines of, like Justice Lindley said, they wanted to stick with a more likely than not type standard, I guess, for lack of a better word. But yes, as Justice Lindley said, that charge by itself, new trial. Like what you guys say, what judges say to juries matter. You guys take the bench and you say, I will instruct you on the law. The juries listen to you.
Before we get, because I know you got a lot of errors, and before we get to vicarious liability or audit trails, because there's a preliminary issue that I probably should ask you at the outset that your opponent's raising with respect to the fact that Ms. Ramsey passed away. There was a notice of appeal after she passed, and they're saying there's no jurisdiction on either of these. Do you want to touch on that briefly before we continue with your list of errors?
Sure.
Alleged errors.
Yep. As the court just brought up, post-verdict, but before judgment was entered, Ms. Ramsey passed away. This was raised on the reply brief.
Notice of appeal was filed. She died on January 24th, 3rd of 23, the notices of appeal both were filed after that. So they say there's no attorney for the state. There's no authority to file an appeal on behalf of of Sandra because she was no longer alive.
Correct.
Yeah.
However, the estate administrator was still alive and well, still a plaintiff in the action. So what we ended up doing was substituting from someone for Sandra's estate. And that's all been
Right.
done.
So we have the son, the same one, but so is it your point that even if we dismiss on Sandra's appeal, because the notice of appeal was filed by a lawyer who didn't have authority, because the state, you still have the husband's estate?
Son, but yes.
Son, yeah, well, son, who's the executor of the husband's estate, right?
Oh, right. Yes, exactly. The estate
So-
administrator was still obviously alive and well.
So are you disputing that the appeal should be dismissed with respect to Sandra and her estate, or, and you're just going on the son's as executor of his father's estate?
Well, both actually. The estate has been substituted at the trial court level. So Sandra Ramsey's son has now stepped into her shoes as
That
far
was
as.
after the notice of appeal has been filed. So the argument is that notice of appeal is invalid.
It was actually, I mean, technically is after the judgment was filed itself.
Yes, correct, yeah.
Right? So,
Yeah.
as I pointed out in the brief, any party, plaintiff or defendant, can move for substitution in that instance. Nobody did because nobody knew. Once we found out, we moved and it was approved, and that procedural hiccup, at least as to Sandra's estate, has been corrected.
Do you want to get to vicarious liability on this Braxton case next?
Sure. At the summary judgment motion, the court determined that unless a specific treatment provider, nurse, or provider was mentioned specifically in the bill of particulars, that there could be no vicarious liability for them. That too was error. There's nothing within the bill of particulars itself that requires specifically naming anyone. This court held in Braxton that exact scenario is not required. And as a result, it was reversible error to do that, because what it ended up doing was limiting who would be considered both an interested witness at trial, as well as who the corporate defendants could be responsible for.
The matter of Braxton was decided in 2022 after the first trial.
It was.
And there was a ruling from the court at the time, pre-Braxton, that you were limited to for vicarious liability of the hospital, the folks that were mentioned. Ms. Reisman, I think, Nurse Reisman.
Yep.
That was before Braxton.
Correct.
They seem to suggest, your opponent seems to suggest that now procedurally, you didn't appeal from that ruling. In the
Correct.
first trial. And now you are procedurally barred, raising on appeal. You only heard on that one.
Sure. The final judgment brings up for appeal all underlying decisions, evidentiary decisions, motions, that sort of thing that make up part of it. So my time for appealing for that can be right now. But on top of that, between trial 1 and trial 2, I moved to amend the bill of particulars because of Braxton, and that was denied as well. So from a procedural standpoint, it's really of no moment. The attempt was made to add names to the bill of particulars, and it was denied by the trial court. And that was after we learned things in the June trial that we did not know.
That's what I was just gonna say. You learned a lot during the trial.
A lot.
Who did what and whose responsibility certain things were, and you were then able to allege it with more particularity.
Correct. Going back to the jury charges in the December 22 trial, the charge that was requested from the trial court was susceptibility of harm. That was not given to the jury. And that too was fundamental error. It's not in dispute that Ernest Ramsey had heart conditions and that he was more susceptible to harm than the average person. I might have been able to wait 4 hours in the emergency room without getting care and survive, but he could not. And the jury never heard from the court that the failure to treat him makes them responsible for all the harm that comes because of his condition. It's basic Humpty Dumpty stuff. You can't push Humpty Dumpty off the wall and say it's your fault for having an eggshell. The same way you can't say It's your fault for having a bad heart. We're not responsible for failing to treat you. And the importance of these jury charges is that it applied to all the defendants. So it clearly could have an impact on liability, proximate cause for anybody that remains in the case.
And then these audit trails that you wanted to bring in an expert. There were some general allegations of fraud and all that, but this deals with the timing of when the decedent arrived at the hospital. Is that primarily what we're talking about here?
Correct.
The 8 o'clock versus 9:41.
Yes, that's one of the things that the audit trail will show.
Would it have shown anything else? Was it the audit trail relevant to any other disputed issues?
Oh, sure. Yeah. Yeah. The audit trail is essentially a log of every time someone does something within the medical record. So if the record's modified, it shows who did it, when it was done, and where they were, meaning what computer they were doing it from. So there was all sorts of testimony in the depositions that this gentleman's lab file was modified post-death by people who testified that they would have no reason to be in that record. Whether or not that's fraud, I don't know, but it certainly is relevant as to whether or not the laboratory record was modified. And if so, that's relevant to what his potassium level really was at the time of death, which also dovetails into the CMP analyzer report that was not turned over. The lab has 2 analyzers, CBC and a CMP. Both of them have an internal lab report that defendant Jones Memorial Hospital's representative said will tell you when the lab was drawn, who drew it, when it was received. We got one of them. And when we got that, we got a response was, this is what we have, and if you want something else, we don't have it.
I know counsel seems to take a position that you moved to amend the complaint to allege fraud with respect to altering records, right? And that was denied. So they seemed, and the trial court seemed to take the position that because you didn't have a cause of action for that, the expert wasn't relevant. Is this still admissible even without those causes of action?
Absolutely, because one of the things that this lab analyzer report is, it's factual. When the lab was drawn, who received it, when it was analyzed, those are facts. The only reason I moved to amend to include fraud, I actually think it's wrong. I don't think fraud applies here because there are no separate and distinct damages.
Well, wait a minute, it was your motion to add it.
The court told me, believe me, the court told me you didn't allege fraud and you didn't allege a cause of action for spoliation, which does not exist. So I moved to amend the complaint to add those causes of action, and that was denied too. I don't know what more I could have done. I was trying to essentially appease the trial court.
But nevertheless, those audit trails will show who knew what, when, and how they acted upon what they knew when they learned it. Okay.
Sure.
Regardless of what your allegations of fraud are, they impact, I would imagine, on the negligence that you were claiming.
Sure, and they're relevant for impeachment purposes and all sorts of things that we get into at trial. The fact that the jury couldn't hear, the other thing about the audit trails is, if you've ever seen one, it's essentially an Excel spreadsheet. It's gobbledygook for most people. The average juror is never going to understand it. And the trial court's suggestion to me was, well, you can cross-examine on it. Okay, I don't know how you do that. Look at all this. Does this mean anything to you? No, it doesn't. I've never seen that before, is how the testimony would go.
So you thought the expert might be helpful to explain it to the jury.
Exactly. And it's part of the plaintiff's medical record. You know, it's required to be maintained. You know, cross-examining with an audit trail is no different than cross-examining with a medical record itself.
You got a lot of other contentions here that you really brief in depth. The motion for mistrial, the adverse inferences, a lot of those. Do you wish to rest on your brief on those? That your time is running short? Do you want to hit like the highlight on one or two of them?
No, I'll rest on my brief unless the court has any questions for me.
All right. Thank you very much.
Thank you.
Good afternoon, Your Honors. Brian Cornfield. I was also the trial attorney in this case for both trials.
And who do you represent?
I represent PA Stevens and Delphi. for the most part, I'm going to rest on my brief. I realize this is a voluminous record on appeal, but I did want to hit on a couple issues. And, you know, where the way I sort of look at this case is that when I look at Mr. Haberfield's appeal, we're looking at two different issues: negligence, liability, and causation. And in the December trial, the jury, which sat for 3.5 weeks, did find negligence against one of the defendants, Nurse Reisman. So with respect to the argument of fundamental errors, all of these points that Mr. Haberfield raises, and I won't go through every one of them because I did brief them. Even if the court takes into consideration that those were errors, and even if they're harmless, or however Mr. Haberfield phrases affected his ability, they did find negligence, notwithstanding all of these.
They found no proximate cause. So I think fair to say that the jury on this issue of what time did the decedent arrive, 9:41 or 8 p.m. or shortly thereafter, it sounds like the jury sided with the plaintiff on that because they found Reisman negligent. In other words, letting him sit there for so long. But then they found no proximate cause, which suggests they agreed with your experts that given his renal failure, all these other conditions, that it wouldn't have made a difference if he was evaluated, triaged, and treated more timely. Is that how you read that verdict?
I mean, to a certain extent, yes. It's tough for me to determine where they found negligence.
Well, they found negligence for
Correct.
something.
Yes, they did.
Probably letting them sit there for so long.
That's a possibility.
The only real, I mean, I don't know what else. And then, but no proximate cause is obvious where that would come from.
Right. And so with respect to, right. And so my point is, even with all those fundamental errors, they did find negligence. So this is a jury that listened to the evidence, and notwithstanding all these errors, which we believe were harmless, and I don't consider errors, they still found negligence. But with respect to the PJI judge, I wanted to touch on that, the loss of chance charge. I mean, at that point in time, there was not a pattern jury instruction that existed. I mean, there was some precedent in the Fourth Department, but that's just a guideline. That was not a pattern jury instruction. Judge Brown was not obligated to follow that, and he has authority to, you know, present a jury charge based on interpretation of the case law. And we're talking about the word.
So can I ask a question?
Yes.
Did you guys discuss the case law? Did you present cases to the judge that says probability, not possibility? And he said, oh, yes, that's the right standard? Or I'm aware of longstanding case law and jury charges that talk about possibility. But as a lawyer in this community for many, many years, I've never heard of the probability. And I just wondered what you and he and the court actually discussed.
I mean, we had a lengthy discussion about that issue.
I mean, case law. Did you rely on any case in particular that I may not be aware of to support the idea of not just the possibility, but the probability?
Your Honor, I cannot recall that. I mean, that's a couple of years ago. I cannot, I don't want to.
Okay.
Mistake
And I don't remember reading anything like that in your briefs about a case that supported that particular phraseology.
Right. Our position is that really that there was no PJI at the time.
Do you think that's an important distinction?
I do think it's an important distinction. And what the point I was trying to get to was whether the word probability or possibility, the plaintiff still has to thread the needle between liability and causation. He still has to show, you know, that whether it's possibility or probability, that negligence was a substantial factor. And he didn't do that. And the jury determined that.
With the incorrect charge, though.
Well, I would disagree that it's the incorrect charge, respectfully, Judge.
So you're suggesting that when we write a decision, we shouldn't just write a decision, we should lobby the PJI to make sure it gets in the PJI, otherwise it's just a guideline.
Well, I mean, there was no PJI for the charge, and I think to retroactively apply that charge to this case would set a dangerous precedent. I mean, when a PJI comes out retrospectively, you could apply it to many cases. And I still don't think it, you know.
PJI is supposed to rely on court decisions, not the opposite way.
Well, I mean, again, the judge, the trial court is afforded, you know, it's his ability to present that charge. I mean.
So my questions do have nothing to do with the PJI. I'm just talking about longstanding precedent about loss of possibility, not loss of probability. And I just wondered where you and the judge, or how it possibly came out that way, I guess.
Yeah, I mean, Your Honor, I'd have to refer to the record. I don't recall it off the top of my head. So
Anything further, Counsel?
unless you have any other further questions, I'll rely upon my brief.
Thank you very much.
Yeah.
Good afternoon, Your Honor.
Good afternoon.
Mary Lou Rocha on behalf of Nurse Reisman and Jones Memorial. And I do recall the situation with Judge Brown and discussing the possibility versus probability.
Right.
And cases were brought before him. And when we were all done arguing, and I do not have those cases in front of me, but when we were all done arguing, the judge said, this is how I interpret these cases. And that's what he based his decision on. He did not say, well, I'm going to make this new law, or I'm just going to go my own way. He didn't do that.
So you think that if I search in the record, I'll find maybe some kind of indication about a case that he relied on, which I will do. I will search the record.
You may, but I'm not sure it was actually recorded. It was in his chambers when we discussed the charge. So I'm not sure. I could go back into my stuff perhaps and find the cases that we've submitted to both defense counsel and opposing counsel. I could do that and submit something else if the court so desires. But that's my recollection of
But to
it.
steal Justice Bannister's question, do you agree that there's a substantial difference between probability and possibility, or are they close enough that either one is good here?
I think that they're close enough that either one is good. In addition to that, this court has held and affirmed in the Gregory case that the overall charge was consistent, and the exact language is the court's charge as a whole conveyed the correct legal standard with respect to proximate cause. That was this court's case, the Gregory case, and was citing the Schmidt case. And to support that, in this case, that the overall charge was sufficient to establish proximate cause was the fact that 3 times in the charge, substantial factors mentioned and stated that you have to find a substantial factor. And indeed, in the verdict sheet, it says, do you find substantial factor? And the court even said that a substantial factor in causing harm to the patient, then the nurse is responsible for the injury or harm. 3 times that was mentioned. And Mr. Haberfield agreed to that verdict sheet, which stated substantial factor.
Well, it's just standard language for causation, right?
Correct.
Yeah.
So overall, the issue of causation was correct.
I guess here's my worry with regard to the possibility, probability situation. You have somebody who had heart disease when they came in. Okay. So, that's sort of, that tips the scales that he's got a heart problem and could die. Okay. The difference between a probability and a possibility in a situation where you have somebody like this plaintiff, I think it matters intensely what the jury hears with regard to, was he probably going to make it or was he possibly going to make it? It's a big difference.
Your Honor, for one, no one knew that he had heart disease when he came in. No one knew he was in kidney failure. No one knew that his potassium level was high. That was only after he passed away that this information was relayed. No one told his wife didn't say, oh, by the way, he only has less than half his heart pumping out what
And
it
he
should
looked
be.
normal. He seemed to be sitting in the chair there talking, and he didn't seem to be an extremist in any way, shape, or form.
He did not. And it did happen in the blink of an eye. The testimony was, he was talking, he was sitting up in the chair. And in fact, when Mr. Nurse Grant moved him from the wheelchair to the stretcher, he assisted and he was helping. He was weak and he hurt all over is all he complained about. And nobody knew these underlying conditions until after the fact. And that's because Dr. Detner, his regular primary care doctor, was not part of the Jones electronic system. He was one of the holdouts that didn't go into it. And it was only after the fact, because nurse practitioner Cox also worked at the orthopedic clinic, who was part of the system. So none of this was known prior to the time that he went into the...
Even if it did, as I read the expert's testimony, even if they knew, even if he brought in immediately, his condition was such that there was no hope for survival.
There was absolutely no
So
hope.
how does that play into the last chance?
He had no chance, Your Honor.
And
That's what
the
it was.
jury heard this evidence, and so any error with respect to probability, possibility is harmless. Is that the point?
Correct.
Review?
Even their own experts said that in order for him to have any chance, any real chance, he had to come in days before. He had to be dialyzed, which Jones Memorial does not have the equipment for dialysis. And the experts testified as to all the things that would be needed to get dialysis, how long it would take. He just didn't have the time, so he had no chance. So that one word, probability, possibility, really has no impact on what the absolute outcome on proximate cause was.
Well, thank you very much. Case number 195 is McGuire Family Properties Incorporated versus the Town of Gates. Mr. Sonner, good afternoon.
Good afternoon, Your Honors. Jacob Sonner from the law firm of Phillips Lytle LLP on behalf of the appellants, Town of Gates, the assessor for the Town of Gates, and the Town of Gates Board of Assessment Review. Your Honors, this case concerns 6 real property tax proceedings, tax certiorari proceedings commenced between 2013 and 20.
Can we just get right to it? Because it's getting a little late and you're probably hungry. We'll get you home for lunch.
I can.
It seems like the issue, maybe I'm wrong, but when the statute talks about stipulate or court order, this is a stipulation case.
That's the sole question that's weird.
So, and the statute doesn't say stipulation, it says stipulate. Judge Doyle in his decision talked about the parties agreed to this. Your client moved for an extension of the deadline to file the note of issue beyond 4 years. So does your opponent argue stipulate means stipulation, which legally has to be under, what is it, 2104, the CPLR?
That's correct, Your Honor.
It has to be written or orally in a court of law.
That's the standard that's been applied by the appellate divisions to date, Your Honor, both in the Con Ed case that we cited extensively in our briefing and the Furbo case out of the Second Department in 1984.
I'm sorry, I said that was your opponent's case. That's your argument, is that a stipulation. Your argument is that to stipulate under the statute means not just to have an agreement off the record, it means to have an on agreement, oral agreement, or a written stipulation, didn't have a court order. Is there any law that stipulate within this 418 means it has to be writing and subscribed like a CPL or 2104 stip?
Your Honor, both the Third Department in the Con Ed case and the Furbo case in the out of the Second Department analyzed the question of whether there was a stipulation in the context of CPLR 2104. So to Your Honor's point, that's either an oral statement, an agreement on the record between counsel for the parties, or a stipulation in writing exchanged by counsel between the parties.
So an oral agreement is not enough.
An oral agreement, that's correct, Your Honor. An oral agreement is not enough. And I would add one point, Your Honor. There's no case out there that demonstrates the opposite is true. So, and that goes for all the cases that are cited in respondents' papers in this case. There's a handful of cases they point to and argue, hey, these are analogous to the facts here where there was some exchange of information or exchange of some terms, and that constitutes, or that's sufficient to establish a stipulation, but those cases are all distinguishable.
So counsel, your client goes in and asks for an extension. Okay, your opponent says, sure. Okay, you agree to an extension. And then you come in, new counsel, and said, aha, no stipulation. I want those cases dismissed. How does that even purport to be fair?
Well, Your Honor, with all due respect, I would say that in the first instance, that wasn't the communication that was made. The motion for more discovery and to generally extend deadlines was not a statement or an offer or a suggestion by the appellants that we're going to agree to an open-ended, as Justice Doyle described, an open-ended extension of the note of issue deadline that would extend potentially beyond the statutory deadline.
But was there any responsible person whose job it was to give the court an order because the court agreed with their motion.
Well, and again, with all due respect, Your Honor, the motion itself was never actually ruled on because the discovery was eventually provided.
Right,
What
because there was an agreement to do so, correct?
And what
Correct.
Justice Doyle describes the situation as having transpired is, while the discovery was eventually going to be provided, and there was a general understanding amongst the parties that eventually there would be an order entered on the record that would extend deadline.
Which is correct, right?
That's correct. That was the expectation at the time. But what ensued over the next few years, frankly, is that and the record bears this out, that there was exchange of these scheduling orders. There's nothing, by the way, in the record that demonstrates what the new note of issue deadlines were being discussed, but these were exchanged. But the bottom line is there was no stipulation to extend the deadline beyond the statutory rule. And there's an interesting line in the Con Ed case that I want to draw the court's attention to. It's in dicta, but there's an open question in the Con Ed case, being the most recent I could find, at least on this point. There's an open question whether the statutory deadline, the 4-year mandate that's set forth in Real Property Tax Law 718, is even waivable, whether you could stipulate around it to
But the
begin.
statute says you could stipulate.
You can stipulate, but you can't waive it. And that's essentially what Justice Doyle is what his conclusion was and why it's wrong.
Well, he said the parties agreed. He equated agreed with stipulate. Because look, your client, Justice Banisher laid it out. Your client goes to court and has a motion to compel, but part of the motion was, Judge, can you move? We have the 5th stipulated scheduling order, right? That was set to expire on January 28th of 2020.
Within a few months of the motion, that's
Right,
correct.
and we get COVID coming in and all that. But so your client says, I'm bringing a motion, Judge, please extend this deadline, right? Beyond the 4 years.
No, Your Honor, it wasn't not to extend the deadline beyond the 4 years, because the 4 years wouldn't pass until.
Extend it from that scheduling order, the 5th scheduling. order.
Correct, Your Honor.
Right. The other side, was this, by the way, argued in court or virtually or in papers only?
Your Honor, you'll forgive me because I wasn't the attorney responsible at the time. Opposing counsel will probably have a better answer. I believe that there was an appearance on the record, but I don't recall.
So, okay, so they're in court. Now we're getting closer to a stipulation if we need one under 2104. You go, not you, but one of your predecessors goes into court and says to Judge Doyle, we got the 5th scheduling order, 5th stipulated scheduling order from May of 2019. We want to extend that. It's supposed to expire in January. Please extend it. Your client's request. The other side in court says, yeah, we don't have a problem with that. There's a motion to compel part of it. We'll get you the stuff. So in court, you asked for an extension. They agreed to it. In front of Doyle, an order was supposed to result. It didn't. But I think the way Judge Doyle looked at it is that was an agreement. Your request was agreed to by them and wasn't reduced to writing or anything, but that's how he looked at it. You're saying, no, you need to get an actual written stipulation or a court order, neither of which happened.
Definitely no court order. And what I would say, Aaron, is like,
because Doyle said it was your responsibility to file it and you never did.
I think Justice Doyle said it, we couldn't benefit. Essentially, appellants can't argue, well, it was never filed, so we couldn't benefit from it not having been filed. And forgive me, Your Honor, I don't know exactly what transpired in that court conference. There's no record of it.
There's no record in our record on appeal, but is there not a transcript of that?
Not that I've seen, Your Honor.
Yeah.
It's kind of interesting to see what was said there.
So we have that footnote from Judge Doyle's decision about it being customary for respondents to submit a proposed order. Maybe that's where we're getting it from. You would disagree with that?
I don't know. I certainly can't vouch for what Justice Doyle had in his mind when he said that. I don't know whether it's customary or not for one side or another to submit a schedule.
You asked for it, though.
Question? You really don't know the answer to that question?
Just about on the customary point, Your Honor.
Right. I'm asking you on customary. You go to court, you make a motion.
Your Honor,
Customarily, the person who makes the motion and then is actually successful, which you were, is the one who prepares the order, unless I don't know what customary means.
Your Honor, I think the key distinction here is that what was asked for in the motion was an extension. That's in the notice of motion. It's in the record. But what was not asked for was the open-ended general extension.
There's a way to fix that too.
I'm sorry, Your Honor?
There's a way to fix that too. You've demonstrated you can make a motion. you can make a motion to end the discovery here, okay? Now, I want to go to a different question now,
Sure.
okay? Stipulate, used in the statute. It doesn't say it has to be stipulated in writing, on the record, or in any particular way, does it?
CPLR 2104 says it has to be,
The RPTL, the statute that we're talking about, that mentions a stipulation, or that it doesn't say the form of that, and it doesn't say stipulation, it says stipulate. Okay,
RPTL, that is correct, Your Honor, doesn't use those terms, but CPLR 2104 does apply in these situations, and the appellate divisions have analyzed the case in the context of that.
Would you agree? I know your argument, there's no stipulation, but would you agree that the parties agreed to an extension? The parties agreed to extend the fifth scheduling order indefinitely, but they agreed. Everybody was on board with that, right?
No, I wouldn't agree to that, Your Honor.
No?
I think what was.
Well, your side agreed to it because they asked for it, right?
A motion was made
Yeah.
that requested, but a motion isn't a stipulation.
No, I'm not saying stipulation. I'm saying, let's take it out of the stipulation land into just an agreement. If the statute said agreed, you say, can you extend the scheduling order to the judge? The other side is in court, says, yeah, we got no problem with that. Would you say that the parties agreed that the order would be extended? Agreed, not stipulated.
I think the context is important here. I think, yeah, sure, there's an agreement that that an order will be forthcoming.
So you're just drawing the distinction between to agree and to stipulate.
Yes, and I think that the distinction has to be made, Your Honor, because of the very nature of our PTL 718, which the Court of Appeals has had is strictly, rigidly enforced. There's
Strict liability statute, but you needed the motion to get your discovery because you're not entitled to it. Special proceeding, you're not entitled to it. You had to have it.
You can, there's discovery.
It's not really arguable. You have to have it.
Discovery, yeah, that's correct, Your Honor. There has to be an additional.
So you had it, and part and parcel of that is this, were the deadlines in this particular order that you had, and it said all deadlines will be extended. That was the order.
That was what the notice of motion requested.
But isn't that what, wasn't the judge signed the previous one that he signed before? That's what's signed. It's in the record.
I'm sorry, Your Honor, maybe I'm not following the question. The notice of motion.
There was a signed order previously, correct?
Yes, the schedule.
Okay, right, the scheduling order, and it gave you permission to do discovery. And it extended the deadlines, and it gave a date, but that date has passed. So then the judge now who issued this decision that you're appealing basically said, well, we all agreed to these new dates, and we asked your firm to submit an order, which you didn't, and you can't benefit from your lack of doing this. Is that accurate or not?
The way I would characterize Justice Doyle's decision is there was a motion made by the appellants to extend the time generally, no date certain, and it was to accommodate additional discovery. And what's that, Your Honor?
for you.
Additional discovery for the appellants, that's right. And what Justice Doyle said is, okay, well, there was at least a request at that time to extend discovery deadlines. And there was a general understanding that those discovery deadlines would be extended. I would not characterize, though, the court's conduct after that as requiring the appellants to submit an order. In fact, the record's clear that the court later called petitioner's counsel, forgive me for using that term, but petitioner's counsel, asking them what the status of the order was and to submit an order.
Do you think if you make a motion for an extension, the other side agrees, the law requires that the court to put a date on the end of the extension, or can it be, hey, you have all this discovery you want, you want all their remediation efforts and the environmental, because that seemed to be the dispute here over whether the value plummeted because of environment. Judge Doyle says, look, I don't know how long it's going to take you, but you can go beyond my fifth scheduling order. However long it takes you, let me know. And then I'll set another deadline later. Do you have to have one in an order, or can it be open-ended?
To satisfy the exception for the order, yes, right. The date has to be set by the order in our PTL 718. Okay. So there's the two exceptions for our PTL 718. There's an order.
Stipulation order. Yep.
Right. And in that case, the order has to, I would submit, has to say, here's
where does it say the order has to, I know there's got to be an order or stipulation, but to extend the deadline, but where does it say it has to specify a particular date?
Well, Your Honor, I don't know how an order could eliminate the deadline unless it did specify the new date.
Okay.
So you would necessarily need a new date in order to overcome the RPTL statutory deadline.
Right.
But from the stipulation perspective, what I don't want to lose sight of this, the fundamental point, which is a general agreement that there's going to be an extension of discovery isn't a stipulation to an open-ended.
But we agree. Off the record, I mean, we understand. I'm not saying we agree. We understand your point is that an off-the-record agreement is not a stipulation. It's certainly not a court order. You need both. The Court of Appeals said it has to be strictly construed. Interest of justice, you feel bad for somebody, fairness, all those are out the window. It really comes down to did they stipulate here? In that court appearance, when you asked for the extension and they said, sure, is that agreement a stipulation? We'll have to take a look at that.
And in particular to essentially overcome the 4-year deadline that's in.
Correct, yeah, for notification.
An extension, sure. General, yeah, but to overcome that statute. And just 2 more points, Your Honor, and I do, forgive me for the first one, because I do feel like I have to make the point for the record. The suggestion that any responsibility for the delays in this case fall on my client's feet, I think are contradicted by the record.
Okay, I'm gonna have to stop you.
Please.
You asked for you are the ones who called the timeout, okay? You brought a motion, okay? They agreed to the, you don't think you have any responsibility, either customarily or by law, to then provide the order to the court, because the court felt you did.
Your Honor, I don't know that I agree with that for the reason I said earlier, which is that the court also reached out specifically to petitioner's counsel to ask for the order. But what I would say is the record is very clear that every time there were discussions about an amended scheduling order in the intervening time period before, in fact, the statutory deadline expired, they ended at the feet of petitioner's counsel, whether there were feedback being given, topics being discussed. It was never finalized, never submitted.
The time that you wanted, the extension you wanted is so that you could get information from the petitioner. Okay, so the court reached out to you. Did you get the information that you sought by this motion that you made, counsel?
I'm not aware of the court having done that, Your Honor, because I think a month after maybe 2 months after the motion was fully submitted, there was a letter provided by opposing counsel saying, you've got everything you've asked for. That was December of 2018. And that was before, December of, I think it was 2019. And that was before the expiration of the initial schedule.
On this issue of delay, and then we got to get to your opponent, but how many times did counsel change for your client? It seemed like there were
0.
I saw Mr. McGuire comes in and he has no idea, like, even where the file is.
No change of counsel, Your Honor. We're all
lawyers within the firm.
Right.
They're from one to another, and then you got one guy knows nothing about the case, can't even find it. Right. And he's asking the other side, what's going on here? I mean, there's a little delay for that, right?
Your Honor, I would say, although this is outside the record for clarification, the first attorney, Alyssa Fortuna, who was on the file for Phillips Lytle, is in Rochester.
Right.
Daniel McGuire, and she left the firm. Daniel McGuire takes on the case. He's an attorney in our Buffalo office, so he's got to get the file from Rochester. There's a simple explanation for that, and I know it's not clear on the record.
Okay. We got you. Thank you very much.
Thank you, Your Honor.
Good afternoon, Megan Doherty of Harder, Secrest and Emery on behalf of McGuire Family Properties. So I think that there were some very astute questions early on as to what happened here. What was the arrangement that was made with Judge Doyle and caused him to, in fact, approve a requested extension of these deadlines? And, I think that some of the characterizations of the facts that the town uses kind of belie or prove up, in fact, their unfamiliarity with what happened. And I'm happy to talk about it. It is outside of the record.
Yes, we'll steer away from that if you would, please. From facts outside the record.
Oh, well, no, just as far as exactly what happened during the conference with Judge Doyle. If the court would.
Yeah, well, since I asked, I guess I opened the door to that one.
Happy to. So yeah, I mean, there was a lot of discovery that happened here. 17,000 pages was given over before the motion to compel was even made. And again, this is the type of case where discovery is not allowed absent a court order. But recognizing that these types of environmental contamination tax assessment challenge cases are slightly different McGuire was working with previous counsel. I think Ms. Fortuna was actually the third counsel that we worked with on this, or lawyer, excuse me, within the law firm representing the town. And we would turn over documents. They would request additional documents. We would turn some over. That resulted in a dispute as to exactly what they were entitled to after we had given volumes and volumes of discovery. And that's what caused the motion to compel. And I would argue that part of the motion to compel, a strategic decision, was to request that extension, because in fact, they're not necessarily entitled to this information absent a court order allowing the discovery. So it was a strategic move, in fact, to request that the extension. And we arrived at court after everything was fully briefed. Judge Doyle actually asked us to talk amongst ourselves, see if we could work out the dispute before he was going to rule on it. We did that. We agreed that all the extensions would be.
You stipulated, so to speak?
That's exactly right. We stipulated that all the extensions would be, in fact, held in abeyance, or all the deadlines would be pushed out, pending our agreement as to exactly what discovery the town needed, because they still didn't know at that point. And in fact, there were emails in the record from Mr. McGuire saying that he thinks that he needs this information now, and that's well after the fact.
But he didn't go back in the courtroom and put on the record, okay, this is the agreement, this, and someone submit an order. That we cannot find that type of transcript, correct?
There is no transcript. That is exactly right. But it was everyone's understanding that to assist the town in getting the discovery that they said that they needed, but they couldn't quantify at the time, but they said that they needed, that the deadlines would be held in abeyance.
So why didn't you submit an order? It was your proceeding, right?
We were working on that. Part of that, I mean, it couldn't be submitted right away because still the town hadn't identified exactly what it wanted for discovery. So we couldn't tell exactly how long it would take for us to gather that information and provide it to them. So, and all the dates keyed off each other. I would point out too, that the 6 previous scheduling orders beyond, this agreement, this stipulation, had in some cases extended this 4-year deadline to file the notice of issue past the original 4 years. There was a case from 2013 that was pending, and this was in 2018 when the request was made. So that clearly that's 4 years later. So I'm not really certain what the town's argument is getting at.
Has this discovery been provided to the town? That you said it hadn't been determined even what they wanted on the environmental contamination. What has that now been identified? Because you still have years that survived within the 4 years.
So actually it has not been fully determined.
Is it identified?
It was partially identified, and it was when this whole issue came up when I reached out again, found out that Mr. McGuire was not at the law firm anymore. And then Mr. McGuire has no relation to my client, by the way.
Right. I was a little confused.
Wouldn't the argument then be that if you didn't have a stipulation, then they're not entitled to any of this discovery in the 4 years and too bad, game over on that.
Well, except that we did provide some discovery immediately, just not the entirety of it. So we relied on the agreement that we reached, that stipulation in court that was approved and granted by Judge Doyle, and provided additional discovery beyond those 17,000 pages that we originally produced. So the town received the benefit of the agreement that we came to and that the judge approved.
Do we have to judge whether you stipulated or not in the context of CPLR 2104? As counsel seems to indicate that we must.
So, I don't think Consolidated Edison is quite as clear as counsel indicates. In fact, there's just one small portion that deals with 2104, and that's with a parenthetical reference to a different case. Excuse me, no, I'm sorry. They after a case was mentioned. And the quote here is, no agreement or assurance from respondents' counsel as to extending the deadlines was reduced to writing or entered into open court. Respondents deny that they made any such representations, and petitioner has not otherwise made any showing that such an agreement was in fact made. So So when they say representations, it's open to interpretation as to whether those could be oral representations or written representations.
But you did agree. There
Pardon?
was an agreement that day in court.
Oh, absolutely there was.
And I haven't heard anybody deny that there in fact was.
You're exactly right. And the town received the benefit of that agreement and now wants to use that agreement to penalize my
So
client.
what we have to decide is that agreement the same thing as a stipulation under 2104? And does 2104 even apply to 418 real property action? Maybe, maybe not. I don't know. We'll have to think, we can tell us.
Well,
Anything
and
further?
I would argue, first of all, 2104 is not the same. There are two different words that are used in the RPTL and the CPLR. Consolidated out of Edison comes out of the third department, which is a different department. And as we've heard this morning, sometimes there's different standards. But beyond that, we would argue that in fact, there were stipulations that were, or writings and representations that were made after the fact that could be viewed as stipulations under 2104. Pardon?
In the record?
Yes, in the record. in
Those
fact.
emails?
The emails,
We
yes.
know under the case law 2104, emails can be a stipulation. So, all right, we'll
That's
take a close
exactly
look at that.
And I think too, the town miscomprehends the difference between, on one hand, you have an agreement to extend the deadlines, and on the other hand, you have set dates. And in the case, and they're two separate things. The Fox Meadow Partners case, in fact, talks about that. It's in the tax cert context. There was an order that was written, stipulation entered. It did not have particular dates in it. And the court there said that just the fact that you agreed to extend in this stipulation, then that means that 718(2)D has been satisfied. So they're two separate issues. The idea of stipulating or agreeing and whether actual dates were set. And that is often for practical reasons, right? I mean, as we saw here, we were assisting the court by trying to resolve this discovery dispute on our own. It was necessary to have the extension in place so that we could do that. We relied on that, but we at the time couldn't quantify exactly how long it would take.
I think we got it.
So I think unless the court has any questions.
All right, thank you very much.
Thank you.
197 is Warren versus Dixon. Mr. Warren is submitting. I believe we have Mr. Trapp here. Trapp, good morning.
Good afternoon, Your Honor.
Oh, yeah, you're right. Yes, my apologies.
No, that's quite all right.
The appellant has submitted, used to be heard.
I got to hear any arguments. That was interesting.
Oh, yeah.
I'm going to be honest with you, I was surprised. I thought even though he's put on the brief that he was submitting, I thought he'd actually show up or change.
He's not shy about arguing.
Yes, but I will be brief and primarily relying on my brief. It's a simple issue. Was the finance director a public official or not a public official? Because if not a public official, everything else fails.
Well, counsel, I have a couple of questions.
Certainly.
But let me hit that issue first. I appreciate that that's with respect to town law. It
Yes.
seems to me that there's some county rules, County Rule 7, I have it, that talks about for civil service workers. This is separate again from being an official, but that there's residence requirements under the county law for being in the town or a contiguous town. I don't think we have that here, unless the personnel officer suspends it or reduces the agreement, which can happen and perhaps still can't happen. But it doesn't, it seems to me the only evidence we have here is that one unsworn document in the record that looks like it was signed by somebody.
Yeah.
But we don't have anything like an affidavit or something saying that, well, I've suspended it for this particular office and this particular thing. And I'm just wondering whether that's just what is the one last thing we need to tie a bow on this under the county law, the county rules.
Yeah, and if I can digress a little, just because I've been doing this a very long time. The county has now gotten to the point where they are allowing people, as long as you live within the county, to take positions because they know how difficult it is getting anybody to do anything anymore. And in this particular case, it all went to the county personnel department. And the personnel department did approve the position and did approve this particular individual, knowing full well because it came from the village of Williamsville.
I don't doubt that there's an approval. The question is the approval because it was, the rule was, the requirement was suspended or reduced, or was the approval made because it was overlooked? And that I don't know yet on this record.
True, that part isn't in the record. I suspect, however, having dealt with Department of Personnel for a very long time, I don't think it was overlooked. I think they simply have just taken that position that as long as it's within the county and the position that they have accepted it, because the predecessor also did not live in the town of West Seneca.
Did they do any of that formally? I think that's what Justice Nowak's referring to, and the problem is that he's, who is not here today, the appellant, and he's saying, look, they have this rule and they have to, and he's brought this, and so it's your burden now to refute that and say somewhere in the record that it's not the rule, there is an exception, and that's what we're looking for. Where is that?
You won't find that particular document beyond what I am telling you has been the longstanding practice of the county of Erie. And if that was the question, then quite frankly, the county of Erie should probably have been a party of these proceedings to explain why they weren't requiring it or enforcing it at this particular position. Something which they haven't done for a very long time.
Right. Well, but the motion's sort of, I mean, the burden, I apologize, is sort of accepted by you once you make the motion to dismiss the petition. That everything here is complying with all laws, not just the town law, but the county law as well. If we reach that issue, just with respect to the personnel director, and the fact that, we don't have that affidavit, I assume is what it would be, saying that it's suspended or reduced the requirement. We still have the issue of standing, whether or not the issue that the court ultimately ruled on. And my only focus with respect to standing, I don't know if the rest of the panel disagrees, but it's with regard to this common law taxpayer standing under the Colella case. And you quoted and cited in your brief near the end, near the very end of the brief. And in Colella, I'd just like to talk for a minute about that case, because it does strike me that in this particular situation, where you have somebody, the sense being that we have somebody that working outside of the jurisdiction that is supposed to be in the jurisdiction. That kind of argument, if you wanted to challenge it, I don't know who would challenge it other than a taxpayer, which seems to be what Colella is for. But Colella does have the parts that you cited at the end. And I know what you're going to get to. You're going to get to the remote, because you said in your brief, it can only be classified as remote. And Colella says, it says at the end, it says it should not be applied to permit challenges of local government officials with no public significance beyond the immediately affected party. So if this was somebody that came forward and said, hey, I wanted that job, instead you gave it to somebody outside of the town, well, that's a person that's immediately affected by the party, so they don't fall under Colella, so that's out. Otherwise, you could say, well, that person has standing, but the petitioner here does not have standing. But then we have this other phrase, by persons having only the remotest legitimate interest in the matter. What does that mean? I mean, you say that it takes interest in the remote. What does the phrase mean?
Well, I would argue, look, in this particular case, there's no evidence of any fraud. There's no evidence of the illegality. There's no evidence that they violated any law in terms of the appointment, because the town law.
If there was, they'd have standing under the general municipal law, under the civil service law. There's other, if you would show that, you get standing under these other things. So
agreed. And none of that is,
but that's why we're only focused on this Colella case and the common law taxpayer standing.
Well,
yeah.
No, go ahead, finish on.
Switch.
No, answer just. No,
okay. Sorry, hold that up. I think there would still, I think to get to the point of a regular taxpayer being able to bring a case, they have to show that it is something more than just, I'm a taxpayer in the municipality. I think they have to show, and I think what that case is talking about is they have to show some illegality, some fraud, something, because they don't have a personal interest in it. They're not somebody who didn't get the job who's then raising the issue. There's somebody else. somewhere in the municipality. We've had
Right,
many a
he
standing
doesn't
argument.
seem to, he doesn't seem to show that in his paper, and I'm gonna give you a real softball, I mean, it's not. And I'm, because otherwise, that's what elections are for, I mean, otherwise, any taxpayer could challenge any action of a legislative body, and that's essentially what he's doing, he's just saying, you know, you're about this residency requirement, and he has no standing on it really, other than this general taxpayer thing, eliminating the, unless you want to argue the opposite. And so,
No. This argument will be coming back up in about 6 weeks when we're here with
Saying
Mr. Warren again.
Mr. Warren again?
Yeah, yes. So the standing issues are rather common.
and someone earlier pointed out we're not the third department. I'll let you hear.
Well, thank you very much, Mr.
Unless there are any other questions.
Thank you.
Thank you.
Thank you.
198 is Neary versus St. Mary's Square Condominium Association. Appellant's counsel is remote. Mr. Special is here joining us courtroom. Mackler, good morning or good afternoon.
May it please the court, Kristen McClure, Gomez Law Firm, attorneys for appellants Reagan Lawn Care. We're asking today for dismissal of the third-party complaint seeking contribution and indemnification. We would note the underlying complaint by plaintiff Neary alleges a slip and fall on ice below a leaky gutter in a parking lot owned by defendant St. Mary's and managed by respondent Andrew Schatt.
Ms. Mackler, could you just adjust your camera a little bit? We're getting half of your face there. There we go. Perfect. Thank you so much.
The complaint names St. Mary's and Andrew Schatt, which then filed the instant third-party complaint alleging Reagan Lawn Care and Landscaping was negligent in failing to remove snow and ice from the parking lot on the day of the accident. Importantly, on the day of the accident, there was no snow in the parking lot. And at the time, Reagan was only permitted to salt the parking lot with permission as on an on-call basis only. They did go to St. Mary's on the day of the accident before the fall. They applied 4 bags of salt to the sidewalks and walkways just after midnight and another 3 bags around 6:30 a.m. They did not plow the
Counsel, I can assure you that the 5 members of the panel here have read through the facts real carefully. If you want to jump to your first contention, that we'd appreciate it.
We would argue that similar to the plow owner in Lingenfelter, even if Reagan failed its duty to monitor as alleged by respondents, it did not cause the dangerous condition of ice buildup in the parking lot below the defective gutter. Reagan merely failed to be an instrument for good, and that's insufficient to impose a duty under Lingenfelter.
Counsel, if I could just go back to something you said a moment ago, and I apologize for being sort of late with the question. The phrase that you used a moment ago, you said that their duty was to be on call only. I see where you got that from. I'm looking at 685 of the record, the email, the follow-up email, December 14th, which again, normally with a contract like that, be considered parole evidence. Gee, what do they mean? When I look at the contract though, and I have the contract in front of me, I don't see anything about on call only. I see that the application for ice control should be the subcontractor is to inspect the site and advise should ice control be necessary, period. I don't see the on call. So it almost looks like this is a separate agreement apart from the contract?
Well, Your Honor, the contract was unclear, to be sure. It references a contractor, a subcontractor, there's a managing agent, but the section that you're looking at also says applications for ice control to be at the discretion of the managing agent. And I would note that Andrew Schatt's witness, Joba, testified that the contract required Reagan to remove snow accumulation of 3 inches or more by 7 a.m., but there would be no maintenance or reaction to any snow less than 3 inches.
Right. No, I have that, but applications for ice control implies that somebody's making the application. The application is going to be at the direction of the managing agent, but somebody's going to make, and then the next sentence explains that subcontractor to inspect the site. That's who makes the application. So I don't know why that you say that this is ambiguous. Is it because it says subcontractor and then the word contractor?
No, Your Honor, it has to do with the difference between the obligation by Reagan to apply salt to the sidewalks and walkways and the fact that they needed permission in order to apply salt to the parking lot. And on the day of the accident, there had been a rainstorm, but there had been no snow. So Reagan did not come to plow the parking lot, but they did come to salt the sidewalks and walkways. And when Mr. Joba was testifying, he agreed that it made no sense to him that there was a difference between their discretion to apply salt to the parking lot versus their discretion to apply salt to the sidewalk. But he did say that it was a cost control measure. It made no sense to him. He testified to it extensively, but he agreed ultimately that St. Mary's treated the sidewalks differently than the parking lot. And that was pages 531 and 532, as well as 523, 543, and 544. So Joba essentially needed to grant them permission in order to salt the parking lot. They did use their discretion to salt the walkways and the sidewalks before the accident. It would be our position that their failure, if they did fail to monitor the parking lot and the ice under the leaky gutter, that was not the dangerous condition that caused the accident. They merely failed to be an instrument for good if they did fail to monitor, and that's insufficient to impose a duty under Lingenfelter. No snow had fallen on the day before the slip and fall, and Reagan had salted. It's our position that just as in Lingenfelter, the cross claims against Reagan should be dismissed, just as they were against the plow owner in Lingenfelter. And in dismissing the cross claim for indemnification and contribution against the Lingenfelter plow owner, we would note this court did cite to Peters v. United Refining, where the third-party complaint against the plow owner in Peters was dismissed under Espinal after it was established that the snow had been plowed and there had been no request for the plow owner to apply salt. This court found that plowing snow could not be said to have created a dangerous condition, and we respectfully submit that the complaint alleging a leaky gutter caused the dangerous ice in the parking lot, which Reagan had no obligation or discretion to abate, and the sidewalks and walkways were salted twice on that day, as required under the contract. Finally, we would note that in Waters v. Simonelli, the plow owner was required to monitor under the contract 24 hours per day, but the court applied Espinal and found no triable issue of fact because the plow owner did not displace the property owner's duty to the plaintiff to maintain the property despite the 24-hour monitoring requirement. It's our position that on the day of the accident, St. Mary's did not grant permission or request Reagan to salt the parking lot until after the slip and fall. And Reagan had no responsibility or discretion to salt the parking lot at the time of the accident.
Right, I think we understand the gist of your argument, which I know you expand on in your brief, which we have read and will reread very carefully. So thank you.
Thank you.
Mr. Special.
Thank you. Good afternoon. May it please the court. James Special for St. Mary's. Just a few quick points. I just want to be clear. I think what counsel was just talking about regarding the Lingenfeld case, they cite to that in their reply brief. I had 2 points in my brief. One was about the contract, the language, this subcontractor as opposed to contractor, that whole thing. 2 was about Espinal. In their reply, all they mention is the Espinal point, which I think that's what counsel was just talking about now. So the first point I would make on that is this isn't an action where Espinal
Right. They're not
matters
suing
at
directly.
all.
Yeah, the plaintiff's not suing this.
You're right.
Person directly.
So I don't think basically everything that's in their reply, and point 2 in their first brief even matters to this because it's all about Espinal, and this is an issue between 2 parties to a contract, not a third party, when they can recover when they're not a party to the contract. So I don't think that is even relevant here. And just on point 1 of my brief, I think the court is right there, or the trial court was right, because their whole point, what their argument was, is, hey, there's this mystery subcontractor that's out there, right? And I think Regan is referred to, or at least there's a question of fact on this, that Regan is the subcontractor. They're sometimes referred to the contractor. It may not always be clear, but that's why there's a question of fact. They certainly were acting as if they were responsible because they would come and take care of the lot. And even if they weren't the subcontractor, and they say, okay, well, we're just the contractor, not the subcontractor. Well, okay, well, the contract also says that the contractor must monitor the north side of the building, which is where this accident happened. So either way, I think there's certainly a question of fact as to whether they had to come over there and make sure everything was all right.
If we agree that the contract is ambiguous, that opens it up not only to those couple of emails that we referenced earlier, that opens up to everything, all the testimony, the history, everything that took place over these few months before the slip and fall.
Right. So, and I certainly think that there is a question of fact. Certainly my client from Andershot, I have trouble with his last name, so I'll just call him Ed. He certainly read the contract as requiring Regan because it was customary for him to call and they'll come out, and I think that's a fair reading when you think that, okay, I call them, they come out, they solve, they do what they have to do.
Their practice is consistent with his reading of the statute, of the contract.
Right. So I think there's clearly a question of fact here, and I think the trial court got it right.
Thank you, Mr. Special.
Thank you.